For your order, item number 1.
For reasons mentioned in the order, this interlocutory application is dismissed.
Item 2.
For reasons mentioned in the order, this is also dismissed.
Obliged.
May it please your lordship, with consent from the respondent lordship, I beg to mention item number 16 of today's date also. My senior my lord D. Cruz has to argue this matter. He has some difficulty today. Lordship, may it be taken after Bihu vacation lordship.
Heard, what is your name?
H. Rahman lordship.
Heard Mr. H. Rahman, learned counsel for the
D. Cruz my lord petitioner my lord.
learned counsel for the appellant. 16, item number 16. Would raise for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. He submits that he has informed learned counsel for the respondent who has no objection to his prayer for adjournment. The prayer is therefore allowed. Let this matter be listed
But Bihu lord.
after Bihu vacation on a date to be fixed by registry.
Obliged.
To accept, I mentioned item 28.
Yes,
Today, we are in the process of filing one more piece of evidence, actually, for the pending IA. So today we want an adjournment. There is a bereavement in the family of the applicants.
you have
So this-
informed the other side. You have to
Well,
inform.
I tried calling them. I'll try again. I tried calling them.
We'll allow you when the matter is called. If it does not reach us in the first half, you may mention at 2. We'll allow your prayer. But you have to,
Yes, it's just that we want to.
no,
file
we'll,
a piece of evidence and then take
before making mention, you have to inform the others.
to reach them.
So you have to wait.
We'll.
We'll allow your application,
Yes.
but you have to inform the others.
My lord, I beg to mention item number 45, my lord. 45, the last item.
Yes. What is your prayer?
My lord, senior counsel Mr. Sayawala won't be available the second half because of his personal inconvenience. So my lord, may kindly take it up after vacation.
Lordship, I'm for the respondent.
You have any objection?
No, Lordship, but Lordship, a date may be fixed.
Okay. Heard, Mr. What is your name?
HK sir.
H.K. Sharma, learned counsel for the petitioner who prays for an adjournment due to personal difficulty of the conducting senior counsel for the petitioner. Learned counsel for the respondent does not raise any objection, hence prayer is allowed. Let this matter be listed on 10th of February.
My lord, there is an interim.
The interim order shall continue till next day.
Much.
Lordship, I beg to mention listing.
Listing senior court
What is
before senior court.
May it please, your lordship. In this matter, my lord, he was arrested on 5/8/2025, my lord, till date, my lord, 157 days. My lord, the survivor and the informant, they have already been examined in the trial court, my lord. এখন দিব স্যার? এটি আপনার report এ? The statement of the prosecutrix, my lord, and the informant. My lord, the prosecutrix has been declared hostile. But my lord, in the cross part, my lord, conducted by the prosecution side, if my lordship may kindly peruse page number 6, my lord. Page 6, para 18, my lord.
6 of this
This, my lord, document. Para 18, my lord.
Yes,
The occurrence did not take place exactly as I had stated before the magistrate and the police. The villagers and Santha members exaggerated it a bit, and they told me to exaggerate and give my statement. That is, my lord, prosecution. And
yeah,
then-
yes, Mr. Sharma.
Lordship, here the exaggeration part as to which is the exaggeration part of the policy.
That, my lord,
Whether she has implicated,
In the constitutional statements.
no, in the deposition.
page 7, if I may be allowed to read, my lord, page 7, my lord, cross-examination by defense. May I read, my lord?
Yes.
Sir teaches math and science in a school. Sir had come to teach me math on 3 Saturdays prior to this Saturday when the occurrence took place. The Sangathan members came to my house and asked my father to file case. My father filed case in the police station around 1 week, 10 days after the occurrence. The Sangathan boys had made video in their mobile phone. The Sangathan people had gone with my father when he went to police station to lodge Ezahar. I gave my statement before the magistrate as per what the Sangathan boys taught me. I wrote half the letter which I submitted in school. The other half was written by my friend Shivani Borwa. The teacher did not force me to write and give that letter. When police examined me, I stated before police as per what the Sangathan people taught me. Next, page 8, my lord. One letter was, my lord, given wherein she implicated the petitioner, my lord. And it was seized.
Yes, otherwise also the victim and informant have been examined.
Yes.
So, yes, Miss. Okay, heard Mr. MK,
MK Das.
MK Das, learned counsel for the applicant. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Miss MK Brown, learned counsel appearing for the respondent number 2. This is your first bail application.
First bail application, earlier, my lord, it was an anticipatory bail application. It was rejected, then I surrendered before police, my lord.
This application under section 483 of BNSS 2023 has been filed by the petitioner Shri Jiten Das,
Thank you.
sorry, Shri Jiten Soikya, who has been detained behind the bars since 5/8/2025 in connection with Sessions Special POXO case number 59/2025 arising out of Bogijan PS case number 20.
Deeply obliged.
My lord, regular bail application, my lord, this is second time. Earlier lordship has considered, but due to submission of charge sheet, my lord, as directed to file before the trial court. My lord, lordship's order at page 26.
Lordship, I need some time to go through the records, Lordship. I could not go through the records.
What is the case? POXO case.
Also, because he appeared today, Lordship. I was under the impression that the respondent is not appearing.
The NDPS Act.
Commercial quantity.
Commercial quantity.
Let the scan copy come. Heard Mr. G. R. Datta, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. It appears that the scan copy of the trial court records as well as case diary which was called for have not yet been received. Issue reminder, registry to issue reminder for the same. Let this matter be listed. 3rd of February. Before, no, 3rd of February. Nidhi. This is tagged with, oh, okay, 3rd of February.
Yeah, please, but can we allow for timing version?
Okay, okay.
Can you pass it over for the time limit?
Okay.
Your Lordship, Lordship, we are newly engaged today and we will file Okalamnama today. Lordship, talks between the parties for amicable settlement is going on. Kindly,
Miss, what is your name? B Datta, learned counsel for the appellant, who submits that she has been newly engaged by the appellant in this case. She has also submitted that in effort of amicable settlement between both the parties is going on. Therefore, she prays for an adjournment. The prayer is allowed.
to fix a date of our petition.
Let this case be listed on 4th of February.
May please, Your Lordship. This criminal revision petition has been filed, Chairman has in order.
Why so many IAs?
No, Lordship, I'm coming on that one.
Okay.
All the IAs are related to RSA 89. That has already been dismissed, Lordship, dismissed for default. Our process for restoration is pending, Lordship. So first, it should be detached. Though out of the same decree. But this CRP has no relation presently and RSA 89 is not alive as on today.
Okay.
As on today, it is an independent law.
So item number 5, 6, 7, 8.
Not required today as on today.
Okay.
Not required. As on today.
Okay.
Lordship, this CRP we have challenged. The order dated
No, those IAs are
are relating to restoration of RSA, Lordship.
okay.
RSA that has been, we have been filed in 2001, in 2012 that has been dismissed. We filed a restoration petition. To our hard luck that has also been dismissed. So now we have filed another petition, Lordship. That is pending.
Yes, what this CRP is?
Present revision is regarding challenging the order dated 4/5/2022, Lordship, in title execution 4/16, where the decree passed in the title suit number TS 28/1989 and reversed by title appeal 3/1999 was put for execution. Interesting case is that, Lordship. If I go back to the history of this case, we have filed with the petitioners, our petitioner interest have filed a suit for declaration of right title in interest and for cancellation of some sale dates. That has been declared by learned Munsif, challenged by the opposite parties in the appeal. That decree was reversed. Interestingly, what Honorable First Appellate Court, while doing the saying that appeal is allowed, suit is dismissed. No contract claim was mentioned on that trial court, Lordship. But while passing the appellate judgment, Honorable Appellate Court has passed some observations. May I, Lordship, draw your kind attention to page number 93, Lordship.
Page number
93 of the CRP.
yes.
May I read, Lordship?
What
The
is
suit-
this? What is this?
This is the judgment of the First Appellate Court.
Yes.
The final order operating party is there, Lordship.
Yes.
The suit of the plaintiff is held liable to be dismissed, which I hereby do. That is our suit for declaration of right title interest and cancellation of sale dates. In consequence of the transfer of land in favor of the defendant number 1, 2, and 3, and the sale dates number so and so, dated so and so, are held to be perfectly valid, legal, and operative in law. As the defendant number 4 is found to be the only living successor to the late Dinaram Singha, she is entitled to entire share left by her father and only brother excluding the land already sold by her late brother Deven Singha and herself. If the sale deeds by which the land were sold to the different number 1 to 3 are found to be inexecutable, for being the land covered by these sale deeds to be in actual physical possession of the plaintiff's respondents having their residential houses thereon, the different number 4 shall be at liberty to execute fresh sale deeds as she shall have share of the land elsewhere. It is further held that if need be, if so advised, the defendant number 4 may approach the revenue authority for partition of her entitled share of the land. Before parting with, it is clear that to avoid confusion, despite death of the pro forma defendant number 4, Chandrawala, reference has been made to her only. However, for all future purposes and references, it is to be alerts of the decision Chandrawala. The appeal is accordingly allowed. Considering the facts and circumstances of this, I leave the parties to bear their own cost.
Was there any counterclaim
No,
before the
absolutely
trial court?
no. That is clear in the WS. We have annexed here with Lordship. Interesting part, Lordship, thereafter. They have filed one execution before the appellate court. That has been admitted. And raising objection, they have withdrawn it. And accordingly, in 2016 again, they have come up before an execution before the Munsif Abhayapuri.
Execution of this appellate
Yes,
court.
Lordship, may I request to page 98, 99, Lordship. Now, the execution petition filed by the present 1, 2, 3, respondent number 1, 2, 3. Page 99, Lordship.
Yes.
Column 10, what sorts of prayer made? The decree holder has filed a petition before the first appellate court, Civil Judge Bongaigaon, having title execution 3/2020, and there was an order of Civil Judge Bongaigaon dated 26/2000 in title execution 3, wherein and whereby learned Civil Judge Bongaigaon directed the ASO Boitamari Revenue Circle to draw a sketch of the entire land covered by the respective dab number this and this, and to deliver possession of 2 kutha 10 leases of land to the Motiur Rahman, different number this 2 kutha 10 leases as per this and that. Now that this is that part, that the respondent preferred regular second appeal before the Honorable Guwahati High Court, hence the execution order passed on 26 could not be carried out. Later on, the appellant decree holder also withdraw the execution petition only to file it to the court of the instance as per the first instance, as per the provisions of 37A CPC, which was allowed without any objection, but the appellant decree holder could not be able to pursue the execution of the appellant court's decree, the Court of Civil Judge Unit Division, due to the appeal by the respondent side, Guwahati High Court. Therefore, it is prayed that the land mentioned in the sale deed be mentioned above be demarcated by the Circle Officer Boitamari, and necessary order to demarcate and the land mentioned below the schedule 1, 2, 3 be passed upon the Circle Officer Bongaigaon, and the bailiff be directed to deliver separate position of the land schedule to describe below in the favor of the decree holder. Petitioner in presence of the concerned lot model. Where is the decree? Where is the petitioner? We are the petitioners, plaintiff of the suit. Our suit got dismissed in appeal. They have no counterclaim. Some observations have been made, which we have put to challenge in 89 RSA. That has been dismissed. If at all that decree, my appeal was not restored, these observations might have some effect of res judicata in filing a separate suit or taking a decree. But here no decree. But they are going for execution of demarcation, then recovery of possession. Totally unheard of. This is one thing. Another interesting is filing of the execution petition before the civil judge in 2000, just after the decree. So we have challenged that by filing a petition under 47 before Munsif, that got dismissed. Now they have proceeded the execution proceeding, Lordship. Recently,
Which order you are impugning?
Lordship, that is the 4/5 page 108, Lordship. Since the written objection on the prayer of the judge, may I read, Lordship? 108.
Yes.
Judgment after under section 47(1) of the CPC, it is submitted the decree, though the judgment was stated that appeal was pending before the Honorable Guwahati High Court, there is no stay order. of the execution. Also seen the order dated Honorable Guwahati High Court, peruse the case record, appears that by the order dated Guwahati High Court, pleased to dismiss the petition and to decree holder allowed to proceed with the execution proceeding. Accordingly, I deem it justified to reject the prayer of 47. These points have been raised before the executing court, that is, it is a non-executable decree, Lordship. At all, there is no decree. Non-executability will come subsequently. It is not a decree at all. Now, in support of their execution petition, they have deposited, I have taken out the online proceedings of the, on last 17/10/2025, Lordship, they have deposited cost for police for getting the decree executed. Then we have, on knowing this, we put an objection and executing court is directed to place the stay order. Okay?
No, what is this?
Only the present proceeding of the execution proceeding, Lordship.
Oh,
Just to show that they have deposited the police even desperate enough to get the decree executed, Lordship, where there is no decree.
no, what is the status of execution
That
case?
the court has directed us to place the stay orders.
Stay
because we
order
have-
from the,
From the, once we have informed that matter of CRP, we have challenged that order and matter is pending for hearing, Lordship.
yes.
Lord, what my learned friend has submitted is not actually correct. The suit was decreed and appeal allowed. But they have challenged that appellate court decree before the High Court. That appellate court decree, their appeal was dismissed. Then they filed a restoration petition. Restoration petition was dismissed. Then again filed a petition for restoration along with a condemnation of delay. That condemnation of delay was dismissed. 3 times the appeal was dismissed. It is an appeal of 2001. Now 25 years has already been passed. And my lord, what my learned friend has submitted that the appellate court cannot pass a decree like that. That is the matter to be decided in the second appeal, not by the executing court. Executive court's power is very limited. It cannot go behind the decree. Therefore, the appellate court has passed a decree that these cell dates are valid and partitions can be made. Where is the wrong? If there is any wrong, they can challenge it in the appeal. And in so many occasions they have come before the High Court. And your lordship passed an order in the CRP 74 of Ethiopia. In this, so lordship can look to the order that is 7/8/2024.
In this case,
Yes.
yes.
7/8. Heard K. Shaharia learned executive petitioner, also heard R. Sudhuri. The learned counsel for the petitioner has submitted he has not fully prepared the case. Prayer is allowed. It is however made clear that pendency of the civil division petition before this court would not be treated as a bar of the executing court to proceed with title execution case in normal courts.
No, where is the decree? Appellate's court.
They have not annexed that decree in the revision petition.
Not challenge that.
They have,
decree, Lordship.
they have not annexed 2 things important. The decree of the appellate court and the objection filed by us in the executing court on their petition, that was not annexed.
We have annexed the decree, Lordship, at page 96. No decree, Lordship. My suit got dismissed. These observations may operate as a res judicata against me
No.
in a subsequent suit. If they file the partition, etc., then perhaps I may not challenge the legality of these cell deeds. Without any counterclaim, they cannot get any decree.
That is to be decided in the second appeal, not by the executing court. Executing court's powers are very limited.
Where is the observation regarding recovery of possession?
Nowhere.
Recovery of possession. In the appellate's court order. Now in whose possession suit lands?
Position lordship.
Where is the order of recovery of possession?
Recovery position is,
Then how possession will be recovered?
but the partition is there. After partition, the order of the appellate court is this. The suit of the plaintiff is held liable to be dismissed, which I hereby do in consequence of the transfer of the land in favor of defendant number 1, 2, and 3. The cell deed number so and so are to be held perfectly valid, legal, and
Yes.
operative in law.
Yeah.
As the defendants is found to be the only living successors of Dinanath Singh, he is held entitled to the entire share of land left by her father and only brother, excluding the land already sold to the late brother Devendranath Deven Singh and herself. If the salaries by which the land was sold to defendant number 1, 2, and 3 are found to be inexecutable, that being the land covered by salary number showing the in actual physical possession to be in actual physical plaintiff respondent having their residential house thereon. The defendant number 4 shall be at liberty to execute the fresh salary and and she shall the share the land elsewhere. It is further held that if it need to be, if so advised, the defendant number 4 may approach the revenue authority for partition of the land over entitled share of the land. Before parting with it, it is clarified that to avoid the confusion, despite the date of pro forma defendant number 4, Chandrabala, a reference has been made only. It is, however, made clear that the reference may allow of the deceased Chandrabala.
May approach the revenue authority
Revenue
for partition. Never approach. lordship.
What is to be executed before there is nothing? What executing court will do?
Executing court will do the, as per our prayer in the execution.
No,
What
sir,
is-
lordship, may I refer to WS lordship?
If the salaries by which the defendant number 1, 2, and 3 found to be inexecutable, the land covered by the salaries in actual physical possession of the plaintiff. Our position is there, the appellate court held.
No, plaintiff means you were not the plaintiff, you are the appellant,
No, we are the defendant number 1, 2, and 3.
or 1, 2, and 3. And you filed the appeal before the first
Yes,
appellate
we
court
filed the appeal. And our appeal was allowed.
allowed.
And
So
they, against that,
It speaks that if the suit land is found to be in possession of the plaintiff, respondent in first appeal,
yes,
then the defendant number 4 shall be found at liberty to execute fresh sale deed. And defendant number 4 may approach the revenue authority for partition.
executable and being the land covered by these sale deeds to be in actual physical possession by the plaintiff respondent, having their residential house thereof. The defendant number 4 shall be at liberty to execute fresh sale deed and she shall have the share of the land elsewhere. Therefore, the land by which we purchase the land from defendant number 4, that is okayed by the appellate court.
Yes, but there is no direction for recovery of possession
We are already in position, the appellate court held the cell ditch, they being land covered by these cell ditch to be actual physical possession by the plaintiff respondent.
Which are the
Plaintiff is,
plaintiff.
they are the plaintiff.
Yes, they are the plaintiff. Therefore, when my cell ditch are held to be correct and valid,
Yes.
then I am entitled to get the possession.
For that, you have to file a suit. There is no direction for either file a suit or counterclaim. There is no direction by the appellate court for recovery of possession. It has only given you a liberty to approach revenue authority
But
to
the
seek partition.
appellate court held we are in actual physical possession.
No,
The partition can be allowed.
for that you have to approach the revenue authority.
The
Executing court will not make a partition.
Executing court cannot allow.
No,
the-
what executing court will do?
Executing court will execute the decree and
That is my question. What it will execute? How it will execute? The decree is of dismissal of the suit where there is no counterclaim. However, some observations were made by the first appellate court that if they are found to be in possession, the defendant number 4 may execute a fresh sale deed, or the defendant may go for
partition.
before revenue authority for partition. This much is the only observation. There is nothing for the it appears that there is nothing for the executing court to execute.
So the executing court, our execution petition is at page
99.
what sort of prayer?
100, page 100. Particular.
If plaintiff suit is dismissed,
Yes.
can defendant go for execution?
Well,
Without,
the appellate court passes order and that
appellate court has,
pass a decree. And that decree is under challenge before this honorable court.
no,
Whether
that is a different, that RSA, we are not going into it. But apparently, what the executing court will execute,
our prayer before the executing court is this,
page,
page 100.
From-
Later on, the appellant decree holder withdraw the execution of so and so and so. But the appellant decree holder could not be able to pursue the execution of the appellate's court decree in the Court of Civil Judge Junior Division North Salmara due to the appeal by the respondent side in the Guwahati High Court. Therefore, the prayer for land mentioned in the cell deed as mentioned above be demarcated by a circle officer, Boitamari, and necessary order of demarcation of land may be mentioned below in Schedule 1, 2, and 3 be passed upon the circle officer. Boitamari and the bailiff was directed to the separate possession of the land. Therefore, this is our.
but there is no direction, such direction either of demarcation or for delivery of possession by the appellate court. You show me.
A direction, prayer for direction is there. Shall lead to actual physical possession of the land and liberty to execute a fresh shall lead. It is further held that if need, if so advised, the defendant may approach the revenue authority for partition of her entitled share of land. Before parting with, it is clarified that to avoid confusion, despite the date of proposed. Therefore, the appellate court held that they can approach the revenue authority.
Yes.
Approach the revenue authority. I cannot go directly. The executive court will issue a writ.
No. That is not the what I am understanding. You make me understand. Appellate court did not say so. Okay, that is a different aspect.
I will let my learned friend on the maintainability. If it is not maintainable, then it is unnecessary to argue.
This case, Lordship, this CRP, they have already strike out.
You are for?
Respondent number 4, Lordship, already strike out by the petitioner. I am the owner of the land. I have sold the land to defendant number 1, 2, 3, Lordship.
Yes.
So the respondent number 4 was already strike out on the prayer of the petitioner. So Lordship, on that ground also this revision petition is not maintainable. And before that, while considering the condonation application in preferring this revision petition, there is an order dated 21/12/2023. I have raised the point of maintainability at that relevant point of time, and it was taken into consideration by this court, Lordship. Order dated 21/12/2023.
Where?
In IA, Lordship. The condonation petition
Which
was there, Lordship.
No, on what point you are raising the?
Lordship, this is a petition under section 115, and after amendment, Lordship, 115 is not applicable, challenging the order passed by the executing court, Lordship. The execution petition is still pending, and only 227 will be applicable in this case. So CRP is not maintainable, Lordship.
Why?
115, may I read for a moment, Lordship?
It can be treated as why it is not maintainable first.
Lordship, the High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto, and if such subordinate court appears to have exercised a jurisdiction not vested in it by law, or to have failed to exercise a jurisdiction so vested, or to have acted in the exercise of its jurisdiction illegally or with material irregularity, the High Court may make such order in the case as it thinks fit, provided that, Lordship, the High Court shall not under this section vary or reverse any order made or any order deciding an issue in the course of a suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings. So the proviso, as per proviso, their revision is not maintainable, Lordship. They have filed a petition before the learned executing court. That is in page, Lordship.
Order copy to be.
They have filed their petition under section 47(1), and we have filed our objection. That is 102 annexure 6, page 102, Lordship. No, Lordship, that is the objection by the petitioners, Lordship, 102 page.
Yes.
So the learned, on this petition, Lordship, the learned executing court passed the order. Page 108.
This is, they are impugning in this.
Lordship. Seen the written objection on the prayer of the judgment debtor under section 47(1) of the CPC, it is submitted by the decree holder that though the judgment debtor stated that appeal was pending before the Honorable Guwahati High Court, but there is no stay order on the execution proceeding and therefore prays to proceed with the execution of the decree. Also seen order dated so and so of Honorable Guwahati High Court. Peruse the case record, it appears that by the order dated so and so Honorable Guwahati High Court was pleased to dismiss the petition and the decree holder was allowed to proceed with the execution proceeding. Accordingly, I deem it justified to reject the prayer under section 47 of Civil Procedure Code and to proceed with the execution proceeding as directed by Honorable Guwahati High Court. Issue precept accordingly, the concerned circle officer is directed to do the needful as per the judgment and decree passed in title suit number so and so in presence of the decree holder and the Nazir of the court. In this case, Lordship, we have prayed to the Revenue Authority for demarcation, Lordship, so that I can execute sale deed in their favor. And as their sale deeds were held valid by the First Appellate Court, they filed an execution petition praying to hand over the lands which were purchased by the defendant number 1 and 2 by those sale deeds. Those sale deeds were
But
already
there
valid,
is no such direction by the appellate.
Lordship, but their sale deeds were held to be valid by the
Yes.
First Appellate Court. And there is a further direction to the respondent, defendant number 4 to hand over to execute a sale deed. So as soon as I execute a sale deed, Lordship, the defendant number 1, 2, and 3 will be entitled for land, Lordship. So they filed the execution petition and we have also filed execution before the Revenue Authority that was sent to the executing court. So the learned executing courts had directed the concerned circle officer to do the needful. So demarcation will be done by the circle officer through the executing court, Lordship. So
No,
execution.
very,
is
if we take it very simply,
Lordship,
this was the case of the plaintiff.
Lordship.
Plaintiff relief was granted by the trial court, which was reversed. That means ultimately plaintiff suit was dismissed.
Yes.
There is no counterclaim. By merely passing some observation by the appellate court that you may approach Revenue Authority,
Lordship. No, I have to execute.
whether
the
the defendant can go for filing execution case.
as because their sale deeds were held to be valid by the First Appellate Court. So they, and there is there is a direction in favor of the defendant number 4 to execute fresh sale deed. As soon as I execute a fresh sale deed and demarcation was done, they are entitled for the lands which they are going to be gained by sale deeds, Lordship. So it is.
Without
far-
counterclaim, without any
so
suit.
far, my understanding,
Suppose your
Lordship,
land
also-
is in possession of, assuming that land over which they are presently possessing, the land which they are presently possessing is,
specific direction that the defendant number 4 will execute the sale deed
may
if
not will.
she is entitled for some lands in some other area also. So the defendant number 1, 2, 3 will be entitled for the lands through which they will purchase through the registered sale deeds, Lordship. Page 96 for a moment, Lordship. If the sale deeds by which the land were sold to defendants 1, 2, 3 are found to be inexecutable. So there is an implied direction by the First Appellate Court that the sale deeds in favor of defendant number 1 and 2, 3 are executable, Lordship. For being the land by these sale deeds to be in actual physical possession of the plaintiff. So if the lands were in actual possession of the plaintiff, they will not be evicted, Lordship. Having their residential houses thereon, the defendant 4 shall be at liberty to execute fresh sale deed, as she shall have share of land elsewhere, Lordship. So they will get lands from the defendant number 4. And in CRP, they have strike out the name of defendant number 4, Lordship. Their petition itself is not maintainable, Lordship.
May I reply, Lordship?
Okay,
May I reply, Lordship?
just a minute. Any other question, issue?
For my understanding, Lordship, this is the scenario that if defendant number 1, 2, 3 are validly entitled for registered sale deeds, which the defendant number 4 will execute in their favor. And if the executing court finds that defendant's sale deeds are lands were occupied by plaintiff, then only the later part will come, Lordship. First executing court has to see whether the sale deeds lands were occupied by plaintiffs or defendants, Lordship. Then only the defendant number 4 part will come, Lordship.
Okay.
So the execution is pending, Lordship, and by this way, defendant number 1, 2, 3 are entitled for some lands, Lordship. If they do not file the execution petition, the debt will be time barred as title suit is pending since 2001, most probably, 1989. That was
First-
3 times dismissed for default, Lordship. Restoration petition filed, that was also dismissed.
Title
for-
suit.
Yes, Lordship.
No.
No, this regular second appeal, Lordship.
No, second appeal is a different issue.
Lordship.
We are in CRP. And suit is not your suit.
No, Lordship.
Suit is their suit.
First, they have to satisfy that this revision is maintainable against executing court's order. And without respondent number 4, how this revision petition is maintainable, Lordship. There is an order, Lordship, by which they prayed for striking ultimatums.
No, I am admitting that, but no, on the last order, Lordship, it is there. On my request, name have been struck off, Lordship.
12,
May
11.
Now,
reply, Lordship.
if their name was struck out, how you are appearing?
Lordship, I am in the RSA, the connected matters are there, Lordship. In the
Okay.
regular second appeal also I am appearing.
And in.
But I have to raise these points, Lordship. They have strike out this, their petition is not maintainable, that I have to inform the court, Lordship.
Madam, you are appearing for Madam. Four. I have got their name struck off, Lordship. Now, again, like, may I draw your attention to 98, Lordship. Page number 98, Lordship.
Yes.
Execution petition, number 1, number of the suit. There are 2 name and address of the parties. This execution petition has been filed by only 3. 1, 2, 3 here. Motiur Rahman, Rubul Amin, Savijan Nisha. Respondent number 4 are not in this execution petition, Lordship. Whatever the madam has submitted, with my humble opinion, Lordship, has no locus standi here.
Okay.
She is not a party in the execution proceeding, Lordship.
Mr. Sharma, any clarification?
Point Madam has raised, just I am clarifying, Lordship, regarding maintainability of my revision petition, Lordship. Revision says the proviso part, which provided the High Court shall not under this section vary or reverse any order made issue in the course of the suit or other proceeding, except where the order, if it has been made in favor of the party applying for revision, would have finally disposed. Here I have come for revision. If my petition is allowed, Lordship, this execution proceeding will go. That's why my 115 is maintainable, Lordship.
If I'm not a party, Lordship, before the executing court, why they made me party?
That was my wrong. That's why I have
Revision
corrected it, Lordship. That's why I
They
have
issued
corrected it,
notice,
Lordship.
then they came
But-
to know that respondent number 4 died, Lordship. There is a direction from court for filing substitution. Thereafter, they.
That was my mistake. That was in RSA. They are definitely relevant parties. I have made them parties.
Yes.
Definitely, I will try to implement them.
Yes, Mr. Sharma, anything more?
But they have not annexed the copy of the petition under 47. 47, 49. Copy of the written objection. And Hmm. 102, they have filed a petition, it is 47. But against this petition, we have filed our written objection. That was not annexed.
What was your plea?
You know,
What is your plea?
Our plea is that the executing court cannot consider again the facts, facts and law based upon which the decree has been passed. The executing court and they has no scope to sit to decide the appeal like or appellate court. There are much differences in scope of appeal and execution. That the contents of the objection has already been decided by the first appellate court. And vividly citing the proposition of law, passes a clear decree. Therefore, my objection that the scope of the executing court, whether the executing court can go behind the decree. This is the decree passed by the lower appellate court, and that decree is going to be executed only by the partition of the land.
Question of going beyond or behind of the decree must exist regarding existence of a decree. Here, no decree exists, Lordship.
No, it is a decree,
That
but
is the
decree of
decree
dismissal,
Dismissal.
dismissal of sir.
Suitable decree, Lordship. Just in a similar situation, Honorable Guwahati High Court, Lordship, I have given
Okay.
the judgment, Lordship.
Heard. Anything else?
My submission is this, that this revision petition is not at all maintainable because under section 47, they cannot raise this point, whether it is executable or not. Because against their decree, they preferred an appeal. That appeal is, of course, pending. Though it is dismissed, the restoration petition is there. Whereas by allowing the petition under section 47, in that case, the whole appeal will be infectious, their period. And they ultimately, by decree passed in favor of the defendant will be satisfied. I got the decree from the appellate court and I cannot execute the decree.
Okay. Heard Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. A.C. Sharma, learned senior counsel, assisted by Mr. S. Bhardwaj, learned counsel for respondent number 1, 2, and 3. Also heard Ms. R. Chaudhary, who appears for respondent number 4, though by order dated 12/11/2025, the name of respondent number 4 has been struck out from this revision petition. Learned counsel for respondent number 4 has raised the plea of maintainability of the instant civil revision petition. Stop. Let this civil revision petition be listed for delivery of judgment on 29 January 2025. Till that date, the further proceeding of title execution case number
4/16.
4/16 shall remain stayed.
Manoj, I have two judgments. One is that as the cell deed is, when the cell deed is executed and registered, it deems to be possession delivered to that effect, and the power of the executing court, whether it can go behind it. The two judgment I will, and I will serve the citation to my learned friend.
When will you provide that judgment? After vacation. Then I will reset the dates because I will need that judgment at least 3-4 days before the date of delivery.
Judgment Ajit.
আজকে দিতে পারবি?
No, you give it on reopening day. Okay. I fixed it on 29th only.
Oblige.
And other matters,
Other matters, Lordship, it will come up on, practically now, we can only, 1 meter may be taken up, Lordship. That is the relevant part is only 67, RSS 67, Lords.
what is that?
Sorry, IA 67 for restoration of my earlier dismissal of the earlier petition for restoration.
We'll take it up after vacations.
Lords.
Item number,
All others are presently not necessary, Lords.
item number
67 only, Lords.
5, 6, 7 and 8. 5, 6, 7 and 8. Show the presence of the council, same set of councils. List this matter after
29. That day also, no problem.
on
Or-
29.
After, no
On-
problem.
on
Because only 1 meter is relevant. If that is allowed, then others will come. Otherwise, nothing will come.
No, their petition for restoration was
No,
dismissed
that is I
with a
admit.
condonation. That condonation petition also dismissed.
Presently
There
67.
there is a
relevant.
petition
For restoration of the condonation.
condonation.
Restoration of 4126, Lordship. Presently only 67 is relevant. Lordship. IS 67 is only relevant.
Let it come on,
And in the meantime, several respondents died.
let it come on 29th.
But it should be detached from 74. Unnecessarily, all the orders that comes on.
No, it will be automatically get detached because the CRP will be disposed of either way on
Right.
that day. 29th.
Oblige.
বাকি কেটা বেলেগ।
Right.
May I please, your Lordship. Lordship, this APG is filed against the judgment dated 30th November 2024, passed by learned Employees Compensation Commissioner, Kasa Silsar in EC case number 43.
Notice are not yet issued.
Notice.
Have you filed the substantial question of law?
Yes,
Which? Where?
on April of 2024. It is there in the record. After the office note.
Heard, what is your name?
KK Medhi appearing on behalf of Mr. SK Medhi.
Heard Mr. K.K. Medhi, learned counsel for the petitioner appearing on behalf of Mr. S.K. Medhi, learned Central Government Council. This appeal under section 20, under section 30 of the Employees Compensation Act 2023 has been preferred by the Union of India and another impugning the judgment dated 30/11/2024 passed by the Employees Compensation Commissioner Kachar Silchar in EC case number 43/2017. After considering the submissions made by learned counsel for the appellant and after going through the materials available on record, following substantial questions of law are formulated in this appeal. Whether the deceased, whether the impugned judgment is perverse to the extent that it did not took into consideration as to whether the deceased workman was a workman, whether the deceased was a workman slash employee within the meaning of Employees Compensation Act 2023 at the time of his death, and whether he died during the course of his employment. Number two, whether the impugned judgment is also perverse to the extent that it did not consider a police report which is exhibited as Exhibit A, which shows the cause of death of the deceased due to hunger, comma. Full stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 11th of February. Let also the records of the EC case number 43/2017 be called for from the Office of the Employees Compensation Commissioner, Kachar Silchar. Registry to make requisition, registry to take steps for requisitioning the aforesaid records, list accordingly.
The learned trial court also granted injunction in favor, thereby restraining the respondent to use the banner of the petitioner number 1 unit. The learned First Appellate Court in appeal preferred by the present respondent set aside my injunction order without considering any arbitrariness, perversity, and capriciousness as required under the principle of Order 43 Rule 1 RCPC. That is why I have preferred this revision petition before your law.
Yes.
Before coming to impugn order, if your lordship kindly peruse my plan to know.
You have
exactly-
filed written objection.
Lordship, I could not file, but I have put the name in when I submit now.
Okay.
Without that. If your lordship kindly peruse my plan and documents. Because the learned trial court passed the injunction order considering all documents relied with the plan as well as injunction application. That the learned First Appellate Court without considering my documents available with the material record, Your Honor, to interfere with the order passed by learned trial court. Your lordship will find my plan annexure 1 at page 15.
Page,
Page 15. 1/5 lordship.
yes.
Your suit preferred by Purvottar Simant Railway Karmasari Sangh, which is zonal union. And the petition plaintiff number 2 and plaintiff number 3 are president and secretary respectively of the petitioner number 1 union. Here, the petitioner number 1 union established in the year 1971. And that is registered union lordship under Trade Union Act. The original copy of Trade Union is with me, lordship. Here, the petitioner number 1 union is established, lordship will find the aim and objective at page 17, paragraph 2 of my plan. To protect the railway employees.
Yes.
Then Lordship, to become this particular trade union has its own constitution, and this is not disputed by respondent side also. Here one clause is there, that is clause number 4. I have quoted it. Lordship will find at page number 22. The qualification for membership. At page 22.
Yes.
Paragraph 5. I have also annexed constitution. May I read the paragraph 5, more particularly the membership.
Yes.
4.1, Lordship. Any employee of the NF Railway shall be eligible to become an ordinary member. So, any employee of NF Railway must be current employee. An ordinary member of the Sangh, that is the petitioner number 1, provided he agrees to abide by the constitution, rules and bylaw of the Sangh and its mandates as formulated from time to time. Next, Lordship, the working committee shall be full power to refuse admission as a member to any member whom they deem undesirable without assigning any reasons, but such person may appeal to General Council of the Sangh. Next provision is their honorary member. This is important, Lordship.
Yes.
Honorary member. The working committee shall have power to admit as honorary member of the Sangh any person who is not a NF Railway employee, but whose nomination as an honorary member to qualify him to hold office in the Sangh is considered to be in the working committee. A railway,
Who are the respondents?
the respondents are outsider, Lord.
They are
They
not,
started to claim as president and secretary of the petitioner number 1 union. This is the exactly case.
on what basis? They claim to be have been elected.
No such document is filed. In fact, they have no original registered certificate. They don't have any PAN card. Subsequently, to claim themselves as president and secretary, they obtain duplicate certificate in spite of having original one as well as PAN card beyond the principle of income tax rule Lordship. Those materials are there and
They are claiming to be the president and secretary of
petition for 1 union.
petitioner number 1.
That is
Okay.
sought for declaration.
Okay.
Now kindly peruse once again, Lordship, the meaning of honorary member. Here first line clearly shows to become an honorary member, first there must be an working committee. Under the clause 4.1, initially membership will have to be taken. Then from that membership, an executive committee will be formed. Then that executive committee will admit honorary member. This is the basic rule of the constitution to get membership. Yes, Lordship, the members who are not even outsider of NF Railway also become a member. But for that, they must take consent of executive committee. This is the basic principle to get membership under this constitution. Then kindly peruse, Lordship, how the petitioner committee was formed, present existing committee. Lordship will find at page 23, paragraph 6. I have referred all facts from last 10 years, Lordship. Also leave is taken, if necessary, I will produce all documents since the date of establishment of the petitioner number 1 union. Leave is taken, Lordship. The history for necessary facts, I have all facts.
Okay,
from
in brief,
2015.
you tell me why, when the trial court granted the injunction,
Yes.
your allegation is that respondent number 1 and 2 are using your name and seal and
Yes.
banner.
Yeah.
Trial court granted injunction in your favor.
Considering all documents.
Why the appellate court vacated the injunction?
Epithet,
What was the reasoning?
find revision. Lordship knows the power of the appellate court. It is also settled principle, Lordship. The appellate court must respect the discretionary power if same is not passed arbitrarily and perversely. Here, if your Lordship kindly peruse the effective order part of the impugned judgment, Lordship, Lordship will find that impugned judgment from page 348. And the effective court, Lordship, will find from page 358, paragraph 8.
Paragraph,
Paragraph 8, page 358.
yes,
Married, Lordship.
yes. What was, yes, please read.
I have found the discussion of the three golden principle for deciding the case under Order 39, Rule 1 and 2. As the code is duty bound to discuss the three golden principle in respect of discussion of temporary injunction, now we find out whether the learned trial court passed the order without following the three golden principle in the grant of temporary injunction. The holding that there is a prima facie case in the backdrop of the appellant is identified as railway employee, and both appellant number 1 and 2 have not presented any documents illustrating their authority in to assume positions on the executive committee as specified by the constitution of the Purvottar Simant Railway Karmachari Sangh. Moreover, the original certificate of the registration of the Purvottar Simant Railway Karmachari Sangh has been provided by the petitioner, accompanied by an audit report and additional proceedings indicating continuity, thereby reinforcing the opposite party's case are the reason why the learned trial court granted the temporary injunction. The above point are strength and weakness of the parties which are not sufficient to decide on the injunction. The appellant stated that they are the president and secretary of the Purvottar Simant Railway Sangh under BMS/BRMS is sufficient to understand the stand. Therefore, who is the real faction of the question organized is the moot question which required to be decided first in order to pass any order of injunction. Lordship, here this hold that thereby the first appellate court is duty bound to Lordship to consider what arbitrary, how that injunction order is perverse, how the learned trial court use discretionary power without considering three golden principles. Here the learned first appellate court did not consider any documents that I have submitted with my plan as well as injunction application. Next paragraph, Lordship. It is the practice that we need to find out the prima facie case primarily on the basis of the petition plan, not on the basis of the defense of the opposite party. We may resort to find out other paramount on the basis of the case of the opposite party. Therefore, the holding of prima facie case on the basis of case of the opposite party and not on the basis of the case of the petitioner is bad in law. The learned trial court decided prima facie case on the case of the petitioner. This is wrong finding, Lordship. I will show the judgment of learned trial court. The next.
So
paragraph.
the appellate court first held that the decision as regards prima facie case was wrong decision.
Wrong decision as because same is based on the case of the
Their
respondent,
case.
not based on
You
the
have not
plaintiff
shown
petitioner.
anything in support of your case.
Definitely, Lordship. If your Lordship,
That was the observation.
basic observation is there. No, Lordship. Apart from that, if your Lordship kindly peruse the paragraph 12, Lordship. I am
Yes.
aggrieved by the findings of paragraph 2. Basically,
12,
paragraph 2 at page 361.
paragraph 12.
Sorry, 12, Lordship.
Yes,
May I read, Lordship?
yes.
The case of the opposite party and plaintiff have equal score. Leans towards both the parties, and as such, at this stage of adjudication, granting injunction to any of the parties would indicate favoring one of them, as the case of the parties are in equal footing. Moreover, there is no declaration sought in the main suit by the plaintiff that the appellant are not president secretary of the Purvottar Simant Railway Sangh under BMS/BRMS. In the backdrop of the same, the granting of injunction in favor of the respondent is based in law. The learned trial court committed error in passing impugn order, as such warrants interference by this court. Lordship, here several judgments are there. I will place all judgment. The trial learned first appellate court can interfere if there is any arbitrariness, perversity. So that findings are not there. Here, learned trial court weighted the case of the both sides in equal score. And here is wrong finding is there, Lordship. I have not sought any declaratory relief as required. If your Lordship kindly peruse my prayer portion in the plan, more particularly Lordship will find my prayer portion at page 33. Moreover, to decide an injunction matter, under order 39 rule and 1 and 2 and under order 43 rule 1, court cannot go under order 7 and order 2, Lordship. Still, kindly peruse my prayer portion. Declaration that the defendants have no right to use the banner of the plaintiff number 1. Then B, declaration that the act of the defendant regarding representation of the plaintiff number 1 union as general secretary and president are completely illegal, unlawful. Then what further prayer is required here? Then my humble and respectful submission, these two prayers are enough. Still, Lordship will find the prayer number C. Declaration that the defendant number 1 being outsider of the plaintiff number 1 union have no right to take part in the open ballot election as general secretary of the plaintiff number union. So all prayers are there. And now kindly Lordship peruse what on the basis of which document the learned trial court passed injunction in my favor. If your Lordship kindly peruse all documents summarily.
No, before that, please read page 360, para 10 and 11 also.
Yes, Lordship. Paragraph 10. Appellant state that the appellant number 1 is not outsider in view of section 22 of Trade Union Act, and that the appellant are also not also filed annual return to the registered of Trade Union Assam for the last consecutive 3 years. Moreover, the appellant stated that they were accepted to be real PSRKS affiliated to BRMS, for which allowed to contest the election goes on the show that the appellant has also brought on record a strong point in its favor. However, these points are yet to be tested and proved. The conclusion of the learned trial court that the opposite party have demonstrated a strong prima facie case against the appellant. Appellant number 1 is identified as a retired employee, and both appellant number 1 and 2 have not presented any documentation illustrating their authority to assume position on the executive committee, as specified by the constitution of the Purvottar Simant Railway Karmachari Sangh. However, until decision on this point that whether the appellant is entitled to hold the post as the retired employee, giving opinion is not warranted. Lordship, the same first appellate court also held that the first learned trial court decided prima facie case on the basis of petitioner's case. Here, the learned first appellate court also repeating same things, Lordship. Paragraph 11, Lordship. The appellant also stated that they, in their capacities as president and secretary of the Purvottar Simant Railway Karmasari Sangh under BMS/BRMS, participate in the election with their nomination being accepted by the returning officer, and that is biennial general meeting of the Purvottar Simant Railway Karmasari Sangh for the NF Railway Zone was held on 10 and 11 July 2024 in Katihar, resulting in the election of the appellant number 1 and appellant number 2 as president and secretary, also requires due consideration. The fact brought on record by the appellant, if proof has a weight of the case. On the other hand, in the main suit, the opposite party as plaintiff has prayed for declaration that the representation of the appellant as the president and secretary is illegal. Until such declaration, no injunction can be granted. Here, ultimately, Lordship, to hold that the injunction are liable to be set aside, the first appellate court did much error in the learned trial court as by not deciding any scope, arbitrariness and perversity as required under Order 43, Rule 1. Now, for a moment, if your Lordship kindly peruse the judgment of learned trial court, Lordship, will find at page 308.
Yes.
Effective part, Lordship, from paragraph 8 at page 16, 316.
What you want to show?
On the basis of which the learned trial court granted injunction in my favor. Basically, on the basis of documents available with the plan as well as injunction application.
Yes.
May I read, Lordship?
Yes.
Paragraph 8. Following a meticulous examination of the pleadings presented, the court notes the position of the petitioner number one, a zonal union for Northeastern Frontier Railway employees, withdrew its affiliation from BRMS in 2020 due to interference and later joined BJMS. Recently, it found the opposite party number 1, a retired employee, falsely claiming to be its general secretary and engaging in illegal activities. The petitioner informed the authorities and filed an FIR against the opposite party number 1. They seek a temporary injunction to prevent opposite party from acting in the name of petitioner number 1 until the case is resolved. Opposite parties stated that the opposite party number 1 and opposite party number 2 are the president and secretary of the Purvottar Simant Railway Karmasari Sangh under BMS/BRMS. They claim petitioner number 1 is an illegal rival fiction from 2021. The opposite party, next page, Lordship, emphasized that the petitioner's registration certificate is invalid and that their names were elected in July 2024. They requested the dismissal of the petition. Paragraph 9, Lordship. The proceeding discussion indicates that the petitioner identifies as petitioner number 2 and 3 hold the position of president and secretary, respectively, of Purvottar Simant Railway Karmasari Sangh. Furthermore, it is asserted that the opposite party number is a retired individual and therefore is ineligible to be member of the petitioner number 1. as stipulated by the Constitution and mandates. The claim of the petitioner are substantiated by relevant documentation. Additionally, it is the posted that the petitioner number 1 was previously affiliated with the Railway Mazdoor Sangh BRMS, but subsequently shifted its affiliation to Bharatiya Janata Mazdoor Sangh's BJMS, following disputed that emerged in 2021. The opposite party contended in their written objection that the petitioner number 1 established in 2021 by individual in rivalry with the Purvottar Simant Railway Sangh, and that they have lost the registration certificate. Next page, Lordship. The Purvottar Simant Railway Karmasari Sangh, for which they have filed an ezahar. Paragraph 10. In absence of adequate proof regarding the documents submitted by the opposite parties, the court observed that the petitioner have provided the necessary documentations, indicating a robust prima facie dispute between the parties that necessitates a comprehensive adjudication through a full trial. Upon next paragraph, paragraph 11, Lordship. Upon evaluation of the facts presented, the court find that the petitioner have submitted documentations, including the constitution of the petitioner number 1, which clearly established that they have been managing the Purvottar Simant Railway Karmasari Sangh for an extended period. In contrast, the documents submitted by the opposite party claim their representation of the Purvottar Simant Railway Karmasari Sangh, despite the submission of only a duplicate copy of the certificate associated with the petitioner number 1. In this matter, the court considered that the petitioner have demonstrated a strong prima facie case against the opposite parties. Opposite party number 1 is identified as a retired employee, and both opposite party number 1 and 2 have not presented any documentations illustrating their authority to assume position of the executive committee as specified by the constitution of the Purvottar Simant Railway Karmasari Sangh. Moreover, the original certificate of registration of the Purvottar Simant Railway Karmasari Sangh has been provided by the petitioner, accompanied by an audit report and individual additional proceedings indicating continuity, thereby reinforcing the petitioner's case. Furthermore, the action of the opposite party are causing considerable inconvenience to the petitioner. Should the court refrain from granting an order of interim injunction against the opposite parties, it would result in irreparable loss and injury to the petitioner and could lead to multiple proceedings concerning the same issue. In the light of aforementioned documents, the court concludes that the 3 golden principles relevant to the granting an injunction favors the petitioner's case. Consequently, the petitioner is entitled to obtain temporary injunction against the respondents. Here, the entire findings is based on documentation of both the sides, Lordship. Therefore, I may be allowed to show all the documents considered by the learned trial court, Lordship. Here, all original documents are under the custody of petitioner's Lordship. The respondent only to use the name of the petitioner number 1, in spite of having original certificate, they filed an FIR. That FIR is also, police report is also part of this case, Lordship. They filed an FIR and obtained a duplicate copy under same registration. Then they also obtained in 2024 October.
The original is with you.
With me. Original PAN card is with me. They again obtained a duplicate PAN card, Lordship, in separate PAN card.
Okay.
While income tax rules is very clear, while a party or institution has a PAN card, then applying second copy or duplicate copy is punishable offense. I will show the relevant law, Lordship. Before coming to, if you want to allow me to show all documents.
No, not necessary. We are not on that. We are on whether the appellate court was wrong
Yes, Lordship.
in rejecting.
Here, my case is based on, Lordship, that original registration certificate, undisputed constitution, and retirement status of the respondent, as well as new affiliation with Lordship, BJMS, all these facts are admitted in their written objection, Lordship. Almost 80% of allegation I have made before the learned trial court is admitted by the respondent side in their written objection.
Okay.
If you are my summary, Lordship, if your Lordship allow me to show my major allegation on the which compel me to prefer this case, Lordship. Lordship will find my registration certificate. I have filed it as document number 2. And Lordship will find I have already some original copy. Still in support of my case, I have submitted the same before learned trial court at page 63.
No, I'm not going into those. Trial court have considered those.
Yes, Lordship.
The appellate court has opined that it is the subject matter of the trial.
Yes, Lord.
Therefore, at the injunction stage, it may not be considered. That is,
Then kindly peruse their written objections and their admission as well as documents submitted by the respondent side. Duplicate copy, which is beyond the principal, Lordship, under income tax as well
they
as.
submitted the registration certificate and PAN card.
Yes, Lord, duplicate copy.
Duplicate,
If
okay.
your
By
Lordship kindly-
filing an FIR.
Yes, yes, Lordship. If your Lordship kindly peruse page number 293. They obtain a police report.
Yes, no, I am accepting your argument you make for anything else.
Some judgment I want to rely, Lordship. Income tax one, if your Lordship kindly peruse Income Tax Act, whether in spite of having a PAN card, the other party can apply duplicate copy.
Section,
Income Tax Act. Section 139A.
yes, please read.
Provided that a person to whom permanent account number under new series has already been allotted shall not apply for such number again. And if apply, Lordship, if it is found in duplicate, then it is punishable up to rupees 10,000. Under Income Tax Act, proviso section 139A. So they only to claim as president and secretary, they not only obtain a duplicate copy in spite of having original one, they also obtain a PAN card.
Okay.
And here the learned trial court also considered that they have submitted income tax audit for 3 consecutive years. If your Lordship kindly peruse their income tax, they submitted income tax only in October 2024, while I preferred this case at a time, not consecutively, Lordship. That documents I have submitted, that is part of my revision petition. For a moment, if your Lordship kindly peruse page number 297. They have submitted on 24/10/2024. At a time for 3 years, only to claim themselves as president and secretary. And I have submitted for last 10 years with a leave to produce all audit reports since 1971. My 10 years audit report is with the case record, Lordship, and leave also taken to produce remaining other audit report. Their PAN card, duplicate PAN card, Lordship will obtain at find at page number 296. And date is mentioned, if I am not mistaken, 6/10/2024.
Okay.
And there are duplicate copy certificate at page number 294.
No, this fact you need
Your
not to
Lordship.
reiterate. You have already made submission.
I want to place certain judgment, Lordship, the power of the appellate court.
Cite your base judgment on a single point.
There are 4 judgments are there.
Yes.
If your Lordship kindly taken up Ramakant Ambalal Choksi,
On what point?
the power of appellate court.
Yes.
Paragraph 21, Lordship. 21, 22, 28, 29, 30, 31, 32.
Yes. What you want to emphasize?
First appellate power, while considered an appeal under 41 Rule 1R, has very limited power. So in temporary injunction is a discretionary power. So learned trial court is the best court to decide how to preserve and protect the subject matter of the property. If there is no any arbitrary or perversity, then learned first appellate court cannot interfere with the decision of learned trial court. So learned trial court, first appellate court must respect the discretionary power of the learned trial court.
Okay, okay.
All 4 judgments held the same lordship, referring other various judgments
On same point.
on almost all same point.
Okay. Yes, Mr. Sharma.
My first objection is that the suit itself is defective, Lordship. So injunction cannot be granted because, Lordship, here is the case, the it was affiliated to BRM, Bharatiya Railway Mazdoor Sangh and Bharatiya Mazdoor Sangh. In the year 2021 or 19, the for a left on their part to hold the annual general meeting and constitute a new committee, the BRMS took the responsibility and they hold a meeting, and the present persons, not present person, that it was like a different number 1 was there and another person they were made president. They continued. And after this new committee was formulated by the BRMS, they have raised some objection. They have stated that BRMS is working against their interests, so they are not willing to continue with BRMS. And they have shifted to BJMS, a new trade union. They took affiliation of BJMS in the year 2021. Now the question will come whether the Purvottar Cement Railway Karmachari Sangh, the name of the plaintiff number 1, which one is real? Because the Purvottar Cement Railway Karmachari Sangh cannot file a case against these persons, because first the question will come to decide before this court that as to whether Purvottar Cement Railway Karmachari Sangh of the plaintiff and Purvottar Cement Railway Karmachari Sangh of the defendant, which one is real? First court has to decide that question. After that, only the question to restrain us will come. Now in the year 2020, this person, the defendants continue with the BRMS. So once they have shifted to other trade union, it will be their duty to prove that their organization is the real one. Without going into that aspect, they have directly come to the court, showing that the Purvottar Cement Railway Karmachari Sangh is the one. There is no dispute regarding that.
No, you said that.
This is not ground even before learned first appellate court. As
That
well
was
as
the ground.
not part.
That was the ground. I am coming to that. So the issue before the learned appellate court was there when a separate organization was there without praying for their, which one is the real organization, how the court can grant injunction. Secondly, your lordship will find page number 272. The appeal. There are other documents also, I am just relying on this. It is their document, documents annexed with that line.
What BRMS stand for?
Bharatiya Railway Mazdoor Sangh.
The affiliation
It is
is not
requested
listed,
that
Your Lordship.
Purvottar Simant Railway Karmachari Sangh is not with BRMS. It is their letter. They are saying that it is not BRMS. Since 21/8/2021. That is important. PSRKS, that is Purvottar Simant Railway Karmachari Sangh, had taken affiliation from Bharatiya Janata Mazdoor Sangh BJMS on 14/8/21 itself, because National Secretary BRMS Sri Ashok Shukla ji very wrongfully appointed Sri Jitu Hazarika, that is defendant number 1, who was working as SSE Construction Master. At that time, he was an employee of railway. So their question now that he is a retired employee, that will come at some later stage. And retired in February 2022, and is currently also a member of ZRUCC. 5-6 years ago, without informing or consulting all of us zonal office bearers, without dissolving the old committee, Sri Jitu Hazarika was declared the general secretary, and as if one makes a will of one's property. Whereas Sri Jitu Hazarika is neither a member of the zonal committee of PSRKS in the zonal level, nor was he a member of the office bearer of PSRKS in the division. Then, under what rule he was made the zonal secretary? In this regard, the correspondence with the officials of BRMS, BMS, and the central level of the zonal division level will correspond to PDF, WhatsApp, email, or registered speed post. But no one listened to us. Then all of us, the original office bearers of PSRKS, member of the original zonal committee, held a meeting and took affiliation with the Bharatiya Janata Mazdoor Sangh on 14/8/2020, and sir, with the support of BRMS, Mr. Jitu Hazarika, member ZRUCC, MLG, Mr. Binoy Singh, member ZRUCC, KIR, Mr. Sandeshwar Singh, member so, Mr. Kusum Lama, Mr. Samir Manna, Mr. Amit Singh, Mr. Dipankar Das, Mr. Pratip Vallabh Das, Mr. Abhishek Pandey. Apart from this, there are some other employees and some retired employees. All of them together have made fake certificate of PSRKS and are openly extorting money in the name of the union elections. Along with this, railway employees and railway administration are being misled, which is a highly punishable offense. Sir, in this matter, we have corresponded in the written form of the General Manager of NFRL Personnel Officer, DRM, of all 5 divisions, as well as Central Labor Commission, State Labor Commission, whose copy are only given with this letter, and you can understand the subject properly. One thing is very clear from this, that the plaintiff had the knowledge that these persons have been made president and secretary, rightly or wrongly. If according to them it is made wrongly, then they have the right to challenge it before the court.
They have challenged.
Lordship, interfering
They
with
did not.
submission, they filed an application for rejection of the plan, all those ground that is
It was a
rejected
wrong
on
order of the lower court,
on
and I am going to
6,
file an appeal.
6/1/2026, just before 2 days.
I am going to file an.
That point is decided,
Yes,
Lordship.
It was
Now,
wrongly done.
in a proceeding under 227, how this point can be raised? When
No.
their maintainability application is dismissed
Only on the point of
on
how-
6/1/2026.
how the court is.
On
court
this
is
point,
correct.
No, not in this manner.
Correct.
Let him submit.
Now, rightly or wrongly, a new committee was formed. That committee continued. And therefore, their first prayer should be that the committee constituted by Sri so-and-so is illegal. That prayer is not there. It is also because they get a period of 3 years for any relief of declaration. This was of 2021. And the committee was constituted much prior to that.
Which committee?
Committee of the defendant. Therefore, they are time barred to file an appeal, file an application claim against the
No, whether that plea has been taken in the Order 39 Rule 1 and 2 application by you.
No. Lordship, this is a question of law. Whether I have
No.
taken or not, that was not, that reply was not filed by me. So I
That
have-
is not my question. My question is whether you have taken that plea.
I have to
when they-
verify. But the thing is that on the basis of record, the appellate court have decided. And now, since it is a very clear that they had the knowledge of the formation of this committee, therefore, without praying for cancellation of this new committee, setting aside the new committee, now they cannot claim that
Where is the the formation of committee has been mentioned. Only the mention is of Jitu Hazarika as appointed as General Secretary.
yes, because of that, they have shifted to BJMS in the on 14/8/2021. So before 14/8/2021, the committee was formed,
Which committee?
Committee of Jitu Hazarika.
Where is the,
From this letter itself, it is clear.
where, show me.
Because there is a gap, then National Secretary BRMS Sri Ashok Sauklaji very wrongfully appointed Sri Jitu Hazarika, who was working as assessor.
It only mentions about appointing Jitu Hazarika.
From the very beginning, I am using. It is requested that Purvottara Symanta Karma
No,
Sangha is
no.
not with BRMS. From the very beginning.
Yes.
It is requested that Purvottara Symanta Railway Conversation is not with BRMS in NF Railway since 21/8/21. PSRK had taken affiliation from Bharatiya Janata Mazdoor Sangh on 14/8/2021 itself. Because National Secretary of BRMS Sri Ashok Sauklaji very wrongfully appointed Sri Jitu Hazarika, who was working as so-and-so and retired in the year February 2022 and is currently also a member of so-and-so. 5-6 years ago, in the year 2024, they have written. 5-6 years ago, without informing or consulting all of us, zonal office bearers, without dissolving the whole committee, Sri Jitu Hazarika was declared the General Secretary as if one makes it will of one's property. So, from this letter itself, it is very clear that the committee of the Jitu Hazarika was formed
Where is the mention about committee?
very wrongfully appointed. Jitu Hazarika is the working.
Only mention about, it
No.
mention about,
You will find in the following lines. Whereas Sri Jitu Hazarika was member of zonal committee of so-and-so, nor was he a member of office bearer of PSRKS and division under which rule was he made zonal secretary. In this regard, the correspondence with the officials of BRMS from the central level to the zonal division, correspondence PDF, WhatsApp mail, speed. Those were no one listen to us.
the prayer is only restraining defendant number
1 and 2.
1 and 2, not the
Now-
main.
Now I come to it will be the answer of your lordship's query. Page 297.
Yes.
With reference to the subject cited above, I am to certify that as per the office record, the Purvottara Symanta Railway Conversation registered number so-and-so has been submitting annual return of the union for the last 3 years in a timely manner. In a timely manner, that has been not reflected in their submission. The President and General Secretary of the Union submitting the returns of the 3 years are as follows. President Kusum Lama, General Secretary Jitu Hazarika, year 2021. Year 2022, President Kusum Lama, Secretary Jitu Hazarika, year 2023, President Kusum Lama, Secretary Jitu Hazarika. Now, the question is, so let me see the prayer in the plaint. Page 33.
Yes.
Declaration that the defendants have no right to use the banner of the plaintiff number one union. Now, first of all, that declaration they cannot pray in view of the fact that the committee constituted with Sri Jitu Hazarika was of a long time prior to that, 5-6 years ago. In the year 2021-22 itself, 21, the committee formed by Jitu Hazarika has submitted the return. Now, one important fact that I am coming right now. Your lordship will find when they submitted return, they have stated that they have submitted return for 10 years. Now your lordship will find page 114.
Yes.
In this 114, there is a seal of receipt of the labor commissioner.
Yes.
This is for the year 2015. For 2014, submitted in the year 2015. Similar seals are there of receipt till 2015 at page 127, 2016 at page 138, 2017 at page 150. Because this is the forwarding letter, there they received the seal.
Now, what you want to
I
show?
want to show that from 2020, there is no seal, which shows that they have produced this document before the court only. They have not submitted there. The defendants, they have submitted the annual return, and therefore the certificate shows that for those 3 years, we have submitted the return. And accordingly, on the basis of that, in the postal ballot, the name of the defendant was appeared, and their claim was rejected. It is the railway authority.
No, in a civil division petition where they are challenging the appellate's court order, you have only to defend that the appellate court's order is right and the flaws pointed out by them are not correct. You need not to raise a new case which you never pleaded
No.
with.
So it is on the basis of record, I am saying, because it is considered by the trial court on the basis of this fault. These faults are there, but despite that, the trial court granted injunction. And now, since the year 2021, these persons are continuing with as a organization. Jitu Hazarika and Kusum Lama, then later Horish Bhia, the defendant number 2. They become the president. Now, suddenly from the year 2024, they got aggrieved. And therefore, can they file a suit claiming that they should not use the banner of the union? Whereas since the year 2021, they are continuing, and these persons are continuing with the BRMS, the original. There is no such that they have considered a new committee and they are using the banner. Now the important question is that they have submitted the certified copy. Who are issued certified copy? No stranger is issued any certified copy by the authority. The duplicate copy issued to the defendants are issued only because they are genuine body. They were affiliated to the trade union, registered their trade union. Therefore, they were issued. And these persons, they are misusing the trade license, trade union registration issued by the trade union by shifting to some other organization without. And as per the constitution, they cannot shift to other organizations. That is not the issue here. But the thing is that since 2020, there is no seal, no receipt of submission of annual return. And in absence of any annual return, how the trial court come to a conclusion that the documents submitted by the plaintiffs have better weight than the defendants? Because these documents clearly shows that they have not been able to show that they submitted the return from the year 2020. And this person submitted the return from 2021. And once a committee is working, now here is the question is that since the defendants are working as a member or president secretary of the Purvottara Cement Railway Commercial Sangh, it was the first requirement to submit a petition. There should be a prayer that the organization of the plaintiff and not that of the defendant is the real one. That prayer is not there in the suit. In that view of the matter, the suit is defective, therefore there is no prima facie case in favor of the defendant, in favor of the plaintiff. Secondly, balance of convenience. Now, these persons are working as a president and secretary, although they are claiming they are making some atrocities, etc., etc. But the thing is that they are the committee, they have the backing of the Bharatiya Railway Mazdoor Sangh. They are doing for the welfare of the members. They have contested in the last elections. And therefore, where is the balance of convenience? There is no such balance of convenience in favor of the plaintiff. Because it is an independent committee, it is working for the welfare of the members, and by granting an order of injunction, the welfare of the members of that organization has been put into trouble. They could not raise any claim during that time. So for the welfare of these members also, if the balance of convenience is looked into, then also for the welfare of the member of the organization is the injunction should not be granted.
Anything else?
Yes, sir. That regarding the membership, the Jitu Hazarika became the member in the year 2021 or before that. He was at that time working. It is clear from their letter. Now, after that, he became the honorary member. There was a committee, the committee took the decision. Therefore, as per their constitution, they have taken the resolution. And after that, what happens? After the new, they continued with the affiliation of BRMS. They have amended their constitution and that was accepted. Your lordship may see page 299.
Yes.
It is letter of 2024. Formation of new zonal committee of Purvottara Cement Railway Commercial and Railway Zone. Enclosed list finding a copy of the proceeding of the biennial general council meeting of the so
What you want to show?
so that the defendants, Purvottara Cement Railway Commercial has been continuing with their activities and they have formed new committee. They have communicated with the authority, Labor Commissioner accepted it. Therefore, the question that these persons are illegal, that question shall not come. So, any order of injunction affects these people. So, balance of convenience is always in favor of the defendants. So, injunction may not be granted and the appellate court is therefore right. Because if they do not file any application, any prayer for declaration that this committee is bad, which they lost due to a lapse of time. Now they cannot file this petition. They cannot get any order of injunction.
Okay.
I want to point out something. Here my learned friend disputed audit return, but they admitted in paragraph 12 of their written objection. What you will find at page 281, paragraph 12. Just admitted position. Again, submission of my learned friend. This is a written objection filed by the respondent. Paragraph 12. Here, they have admitted. With regard to the statement made in paragraph 8 of the petition, the opposite parties begs to state that it is true that as per Act 1128 of the Trade Union Act, every union has to submit audit return of the registrar, and reporting submission of the annual return by the petitioners have nothing to say. That the statement regarding submission of last 10 years audit report. They did not dispute it. Rather admitted, yes,
It is only
they have nothing to
because
say.
since 2020, from 2015, they have submitted the report. Since 2015, both were together, but after that, once this person has been made president and secretary, they became offended, therefore they left the organization and used the name of the organization itself.
Next paragraph, Lordship, page number 23.
Then subsequent
13.
sentence.
Page number 13. Having bank account and my PAN card. That is also not disputed. In paragraph 13. Then, Lordship, their status of retirement, which is against the rule of constitution, that is admitted, Lordship, at page 280, paragraph 9. They admitted, yes, they are retired person. Paragraph 9 against the reply of paragraph 5.
Okay,
Same admission, Lordship will find at page number 282, at page 16, and page 283, at page 17, regarding their status of retirement, which is against
Lordship, let
constitution.
them read the paragraphs.
no,
Because I have stated that I become the honorary member. Then there is no such admission. Yes, I am retired, that I have to admit.
Yes.
But a retired member can become a honorary member in the subsequent sentence. I have stated that I have become honorary member by the
After
committee.
having an
Working
executive committee.
Yes, that
Executing,
is as per
that
law.
means executing committee
as
will
per the
come
constitution.
from the members of existing employee. Then, Lordship, they have not preferred any counter claim challenging my status.
I have not filed my WS till now. Therefore, the
And
question
their
of
status regarding
submitting
maintainability
counterclaim
of the
shall
suit,
not come till now.
Lordship, they immediately on 85th day, after 3-4 times hearing in injunction application, they filed an application on 85th day under Order 7 Rule 11 for rejection of the plan, Lordship, on maintainability ground.
no repetition. You have already
Yes,
heard Mr.
Now,
Arani.
my last submission is that since they have not made proper prayer in the plane and the suit is time barred for any prayer for the selection, even if I don't say making of committee, but the selection of Bhitu Hazarika as a member or president or secretary, since they have made, which was done 5-6 years prior to 2024. Therefore, the suit itself is time barred, and therefore on the basis of a time barred suit, the court cannot grant any injunction to the.
Whether this plea was taken before the,
What I am submitting is
no,
that
no.
whether
First,
I-
you answer my question, then give
Okay.
explanation. You have to first answer my question,
perhaps not.
then you have to explain it. That for this reason, it was not taken or for
Because
that
this
reason.
time barred probably I have taken. But I have taken that in the recent petition that has been wrongly rejected, so I am going to file an application before this. So, but what I am saying that this is a question of law. And question of law, I can raise at any point of time, at any time of the proceeding,
Okay,
whether before the appellate court or before the tribunal court. And that point is a substantial point I can raise before this one. I will.
heard Mr. Arani, learned counsel for the petitioner. Also heard Mr. R. Sharma, learned counsel for the respondents. This
One more thing, Lordship, I am interrupting your Lordship.
yes,
In the written objection, they have submitted annex with their appeal, their revision petition. The last annexer, they have not annexed. So,
I have 35 copies of entire written objection filed by my learned friend. I have.
no, annex, document.
this
yes, that is
application under Article 227 of the Constitution of India has been filed by the petitioners, namely Purvottar Simant Railway Karmachari Sangha. Number one, number two, Miss Anita Singh and Mr. Polish Mushahari, impugning the order dated 28/5/2025, impugning the judgment and order dated 28/5/2025, passed by the Court of Law and Additional District Judge number 3, Kamrup Metro, in Miss Appeal 1/2025, whereby the order dated 17/12/2024, passed by Learned Civil Judge Senior Division number 1, Kamrup Metro, in Miss J case number 1111/2024, was set aside by the aforesaid order. The trial court had granted temporary injunction in favor of the present petitioners, restraining the present respondents from using the banner where is the impugned order? Page number?
Page number 308, Lordship.
Restraining the present respondents from engaging in activities under the name and banner of the petitioner number 1 union until resolution of the dispute pending in title suit number 633/2024. The facts relevant for consideration of the instant civil division petition is that the present petitioners as plaintiff had filed a suit bearing title suit number Learned counsel for the petitioner has submitted that the impugned order passed by the first appellate court is liable to be set aside on the ground that it interfered with the order of the trial court granting temporary injunction in favor of the present petitioner without coming to a conclusion that the trial court had exercised its jurisdiction with arbitrariness, capriciously, or perversely. Stop. He submits that the first appellate court, without finding any perversity of the order in the order passed by the trial court, had illegally set it aside. It means that the present, he also submits that the trial court, while granting the temporary injunction in favor of the present petitioners, had relied on the documents produced by the present petitioners, and only after consideration of the documents and materials produced by the present petitioners before the trial court, the temporary injunctions was granted. However, the first appellate court came to a wrong finding that trial court came to the conclusion of a prima facie case, having a prima facie case in favor of the present petitioner, basing on the case of the present respondent. He submits that the observation made by the first appellate court that the ingredients of three golden principles for grant of temporary injunction are not present in the present case was wrong, inasmuch as the respondent number 1, who is sought to be injuncted, as he is claiming to be the secretary of the petitioner number 1 association, is a retired employee and he cannot hold the post of any office bearer of the petitioner number 1 association under the constitution of the association. He further submits that the petitioner, while praying for grant of temporary injunction, petitioners, while praying for grant of temporary injunction, have provided all necessary documents like registration certificate of the petitioner number 1 association, original PAN card, the annual return before annual income tax return, annual audit returns. And on the basis of the said documents, he submits that the trial court granted temporary injunction in the favor of the petitioners, whereas the first appellate court has wrongly observed in paragraph number 9 of the impugned judgment that trial court decided the prima facie case in favor of the petitioner on the basis of the case of the appellant, that is the respondents, which is not true. Stop. Learned counsel for the petitioner has further submitted that the respondents only to have a copy of the registration certificate and PAN card of the petitioner number 1 association had filed an false FIR when
They obtained a police report actually, also. They did not annex
false FIR and thereafter obtain the duplicate copy of the registration certificate and the PAN card.
report obtained on 10/2/2020.
Stop. He further submits that what else is your submission?
So basically, paragraph lordship 12. The learned court
Yeah,
appellate court
just
rated the case
interesting.
of both sides at page 361. Weighted the case of both the side.
Okay, okay. I'm reserving the judgment. Heard,
Only thing I want to point out, as your lordship the query, also may see page 76 of
Yes.
the
Yes,
revision. Here, after selection of Sri Kamal Dahal, the police occasion of Chhath Puja, the General Secretary of Bharatiya Rail Mazdoor Sangh made a visit to the Guwahati, convened the executive meeting by WhatsApp and formed another committee. In that committee, 5 to 10 were railway employees. Page 76, last para. Five to 10 were railway employees and rest were hired from outside. The General Secretary of the Bharatiya Rail Mazdoor Sangh, without consulting the President of the Zonal Committee or the Zonal Committee, appointed the and declared such persons as President and General Secretary of the NFR Workers Union, who is no way connected with our organization. Is their letter.
what is this?
This is a letter issued by the plaintiffs to the Bharatiya Mazdoor Sangh, BMF, and Bharatiya Railway Mazdoor Sangh.
Okay.
So since they were
Heard, so and so. Hearing concluded, judgment reserved. After due vacation.
one more thing, this document, this is the last page of the WS, our objection. Here, this is the list of selected unions. Here, the name of the opposite party is here. They are selected, they were allocated symbol. And name of the plaintiff was
Putul.
separately given. And they were rejected. So, two Purvottara Seemanto Railway Karmachari organization is there. It is clear from the record. So the question definitely comes whether they have to first pay for declaration that there is the only real organization or like that. Without that, they cannot pay for any relief of declaration.
This ground is taken in order 7 Rule 11 application. If your lordship allow me to submit the objection as well as
Not a part,
No.
it is not a part of this case record.
your application and my objection, which was rejected.
You give it to me.
This is their application and my objection.
Pilot, may I seek your lawful indulgence to make a fair this related amendment?
Yes.
My lord, item 22, I'm having some difficulty in the second half. I need to file my reply. I'm the appellant here, it's a matrimonial appeal. The other side have filed their objection. I need to file my reply. So it may be taken off of you.
Who is the for? Who is for the other side?
Item 22.
Heard Mr. J. Patwari, London Council for the Appellant. Also heard Mr.
D. Chaudhary.
D.
Chaudhary for the sole
Cha-
respondent.
D. Chaudhary appearing for the sole respondent. London Council for the Appellant. What reply?
My lord, they have filed their objection, bringing in some accession liabilities in the affidavit. I have to respond to them. To their objection.
This is an appeal.
This is
In
an
appeal, you cannot go and filing reply and reply.
True, but
Who seeks an adjournment on the ground that he intends to file a reply to the written objection filed by the respondent in this case. Retrial is allowed. Let this matter be listed after being vacation.
Deeply aware.
Item number 19 and 20 order. Monologue case. My lord, last time it was sent to the mediation, so not settled. So TCR also available. Both the parties are there. So fixed for hearing now. Please appear for the claimant. Both the cases.
But Mr. R.C. Paul, learned counsel for the
Appellant.
appellant. Also heard Miss E. Devi, learned counsel for respondent
Number one.
number one. It is submitted at bar that both these appeals are ready for hearing as records of the Motor Accident Claims Tribunal have already been received. And therefore, let these matters be listed for hearing
ACL also in the.
when
In the month of, as usual, it's coming. This is a case of my lord.
Kindly, date may be fixed on the month of March.
My lord, first week of March.
in the first week of March on a date to be fixed by registry.
My lord, March.
Item 44. Let me pass for the timing.
What is the matter?
As of yesterday, it has been part heard.
Okay,
For the timing, lots. This comes in his own legs.
timing. After something.
Timing at a 13.
Yes.
Lordship. Dear Lordship, the incident relates to POCSO Act, Lordship. The victim, Lordship, already charges has been framed under 65(1).
Why trial court rejected? Why trial court rejected your prayer?
Sir, I have annexed the order.
Because at this stage, Lordship,
Yes,
the
30.
victim has not yet been examined.
Court said, madam, nature and gravity of offences sheeted and the fact the trial of this case has not yet been commenced. In my considered opinion, release of accused person on bail at the very least
Okay.
is not proper.
Lordship, the fact that the father has appeared, Lordship, and compromised the matter, that cannot be a ground for offence under POCSO.
Yes.
Lordship, and the next date I have gone through, Lordship, is fixed on 21st, this 21st, Lordship. So, Lordship may call for the updated deposition of her, Lordship. And since they are appearing here, Lordship, they may well appear before the trial.
Next date is for
Evidence.
statement of the victim girl.
So they can ensure, Lordship, that the victim girl appears before the court and depose witness. Thereafter, Lordship will consider the bail application.
My submission, my lord.
On warrant of arrest, Lordship. And for Lordship, the service report is still awaited, Lordship.
POCSO case.
Oh, I'm sorry, Lordship, this is 370. I'm 370. In respect of subsection 3 of 376, probably I might have. Yes.
The case is at the evidence stage, Lordship. Victim and the informant was examined, Lordship.
Why you,
But my lord, I'll very candidly submit that ever since then, I have not been able to establish contact with my client. So I'm not really aware as to what his current circumstances are. That being said, my lord, if I go to the merits of the case,
no, on the interim, in the interim relief order, was there any condition?
no, my lord. there
No
is
condition. Okay. Have you contacted the whether he has contacted the investigating officer? Not aware.
I have not been able to at all.
It is at investigation stage or trial stage?
Investigation.
CD is there.
Yes.
Has he
No.
cooperated?
No, Lordship. And Lord, let him submit, Lordship. Then
Yes.
So my lord, if I go to the merits of the case, he was shown arrest, my lord, on 1/9/25. And then, my lord, he was granted the interim bail on 23/10. He was actually released on 23/10. So 52 days of custody was there. Judicial custody was there as of 23/10/25. The sections, the provisions of law under which this FIR has been registered are 3184 and 3162. That is 420 and 406. So both have a maximum mandatory period of 60 days. 112 subclause 2 later of the BNS was added later on. That is organized crime. Now, my lord, since this petitioner is entangled in a number of other criminal cases, so I raised this law point as to whether this period since which he was shown arrest till this day can be taken into constructive custody, can be taken as constructive custody for the purpose of default bail. So, my lord, a coordinated bench of this Honorable High Court has.
No, what is your?
My lord, I was shown arrest on 1/9/25.
Yes.
And I was granted.
Shown arrest in this case.
Yes, in this case, my lord.
Yes.
And then I was granted interim bail. I was released on interim bail on 23/10/25.
Yes.
So, my lord, as on 23/10/25, that becomes 52 days.
Including the period during which you were on bail.
No, my lord, without the bail. On 23/10/25, it's 52 days.
52 days.
Yes,
Okay,
my
okay.
Now, my lord, this period, this intervening period, since
During which you were
I
on
on
bail.
interim bail, yes, my lord.
You want
I
to
had-
add this to?
Yes, my lord, I had
No.
made a submission.
No.
My lord, one of the coordinate bench, my lord, has kept that law point, taking into consideration number of judgments. My lord, I had given my judgments. The state had also given some judgments. And my lord, the judgment is still late. It's in CAB.
What is the judgment in?
My lord, this is the order of the coordinate bench.
No, will you justify?
My lord,
What
by
is your
Sandeep Kumar Bafna.
submission?
My lord, Sandeep Kumar Bafna and the Odisha High Court.
What it
My-
says?
They have categorically said that this period is to be treated as constructive custody. Not the
Sandeep
Kumar
Bafna says.
No, Sandeep Kumar Bafna does not say categorically, but Sandeep Kumar Bafna lays reliance from a case in 1976 Niranjan case. So that Odisha High Court, Honorable Odisha High Court has placed reliance on Sandeep Kumar Bafna and then has said that interim period can be taken as constructive custody. If I may place the judgment, Your Lordship.
Yes, though that judgment is not binding, but we can go through it.
My lord. So firstly, my lord, I'll place before Your Lordship the case of Sandeep Kumar Bafna. The relevant paragraph, my lord, will be paragraph 16.
Paragraph?
16. My lord may go from paragraph 9 onwards. But then
No,
the
come
relevant-
directly to
My
the,
lord. So my lord, paragraph 16. May I read paragraph 16?
yes, what was observed?
My lord, that the relationship between custody and vis-a-vis arrest. If I may read the paragraph, Your Lordship.
But that is not in dispute.
My lord.
Here the question is whether the period during which you are on bail,
My lord, that's specifically answered by the Odisha High Court.
let us go directly
Yes,
to
my
that.
lord. Para 26 and 27.
Para?
Para 26, my lord. 26 and 27.
Yes.
The word custody has not been defined in CRPC, yet there is no cavil that the accused who has been released on interim bail is deemed to be in constructive custody of the court in Cecil. In this context, it is apposite to refer in the judgment of the Apex Court in the case of Sandeep Kumar Bafna, wherein the Apex Court quoted the approval of its earlier judgment in the case of Directorate of Enforcement versus Deepak Mahajan, reported in 1993, 3 SCC 440, and that of Niranjan Singh versus Prabhakar Rajaram Kharote, reported in 1980, 2 SCC 559. Thus, the court gives power of arrest not only to a police officer and the magistrate, but also under certain circumstances or given situations to private persons. Further, when an accused person appears before a magistrate or surrenders voluntarily, the magistrate is empowered to take the accused person into custody and deal with him according to law. Needless to emphasize that the arrest of a person is a condition precedent for taking him into judicial custody thereof. To put it differently, the taking of the person into judicial custody is followed
after the arrest of the person concerned by the magistrate on appearance or surrender. It will be appropriate at this stage to note that in every arrest there is custody but not vice versa, and that both the words custody and arrest are not synonymous terms. Though custody may amount to arrest in certain circumstances, but not under all circumstances. If these two terms are interpreted as synonymous, it is nothing but an ultra-legalist interpretation which, if under all circumstances accepted and adopted, would lead to a sterling anomaly resulting in serious consequences. Why Dawson BV? While interpreting the expression in custody within the meaning of section 439 CRPC, Honorable Justice Krishna Iyer, speaking for the bench in Niranjan Singh versus Prabhakaran Rajaram Kharote, observed that he can be in custody not merely when the police arrests him, produces him before a magistrate and gets a remand to judicial or other custody. He can be stated to be in judicial custody when he surrenders before the court and submits to his direction. My lord, this point is important because my lord had renewed by interim order. If the third sentence of para 48 is discordant to Niranjan Singh, the view of the coordinate bench of the earlier vintage must prevail. And this discipline demands and constrains us also to adhere to Niranjan Singh. Ergo, we reiterate that a person is in custody no sooner he surrenders before the police or before the appropriate court. My lord, thereafter para 27. Hence, on the touchstone of the authoritative pronouncement of the apex court in the case of Sandeep Kumar Bafna, it is held that by virtue of interim bail granted, petitioners are deemed to be in constructive custody of the court in session. And since for reason already stated, the impine order is set aside, the interim order is made absolute till the conclusion of trial on terms fixed while releasing the petitioners.
BNS is. '" What is the corresponding provision of that 167?
7, my lord.
One 187.
$187, my lord.
The word used in 187 is detention.
My lord, but my submission is that, my lord, I have surrendered before this honorable court.
But
And
you
I
were
am-
granted bail.
Yes, my lord, on the directions of this honorable court, which was also, the interim custody was also extended. The interim bail was extended. I'm
What
sorry
is
for
the
that.
difference between interim bail and final bail?
So, my lord, had I not, the interim bail, had it not been extended, then that would have been a different scenario. I would have not adhered to the conditions given by this honorable court. But since I'm already adhering to the conditions given by the honorable court, my lord, my submission is that we will fall under this when he surrenders before the court and submits to his direction. So, my lord, I'm submitting to the honorable court's directions. That is what my submission is, my lord.
Yes.
Lordship. My lord, just my lord, may I make one more submission? My lord, 2 more cases were taken up before the coordinated bench, since it's entangled in number of cases. All those cases have been put up before the appropriate bench, which has marked the order as CAB. I'll just give the, this is my lord.
On this question, whether custody period.
Yes, yes.
No, this can be decided by this court also. If there is conflict of opinion, it will go to
Your Lordship will kindly peruse the last order.
So what is your final submission? That the period during which he remains on bail, interim bail,
That is to be included as
computed,
constructive custody.
and he is entitled to get
Default.
default bail.
Yes, since charge sheet has not been.
Whether Odisha High Court has held that,
Yes, my
which para?
27, my lord. Although, my lord, the Odisha High Court was dealing with the anticipatory bail application, not with the regular bail application.
Yes.
Also, the last order did not appear before the IO Lordship.
Yes.
Probably there was a direction. Lordship.
Which order?
Last order, Lordship, passed by your Lordship. I mean, the second last order, Lordship, 10th bill.
Yes.
Yes, till 8th of January, it was conditioned that the petitioner shall appear before the IO of Nimati PS case as and when so required by the investigating officer. Dear Lordship, if Lordship sees on the last date, he was granted interim despite not appearing before the court, Lordship, on a date, Lordship, that he is suffering from, he has some treatment going on in GMC. That was his statement, and upon that, the interim was extended, Lordship. Now, I have gone through the records, Lordship, there is no document of the GMC. The additional affidavit, Lordship, will find their additional affidavit. Lordship, can you take up their additional affidavit?
Yes.
There, Lordship, will find at paragraph 5 and 6. Paragraph 5, they have stated that the aforesaid surgery at Arya Hospital, he got infected with chickenpox, and also subsequently he had developed post-operative complication, thereby compelling the deponent petitioner to visit GMCH for further medical evaluation. Upon examination, the attending doctor at GMCH advised the deponent petitioner for immediate hospitalization due to an excessive infection arising from the earlier surgical procedure. The petitioner also advised to undergo additional surgery of the removal of gallbladder stone measuring 7 mm. In my copy, Lordship, there is no such document. What you will find the annexures at page 35. This is the Arya Hospital annexure. And page 36 is also Arya Hospital certificate. So in spite of being released on discharge on 15/11/25, he was specifically directed to appear before the court, Lordship. The date, Lordship, I have forgotten in the first interim order. He did not comply with that order also, Lordship.
Regarding the submissions made by the petitioner's counsel,
Yes, Lordship, in my limited knowledge, Lordship, I think it refers to parole, Lordship. The under trial who is on parole, then constructive custody is done. No, if I'm not wrong. Otherwise, I have to go to the other judgment if they are available, Lordship. Because
you are relying only on Odisha judgment.
And also the Sandeep Kumar Bafna, my lord. Because if I have to go through the jurisprudence which is evolved, then the number of judgments will come in the picture. But the Honorable Odisha High Court has simplified the entire, summarized into one paragraph. That is why I'm relying on the Odisha High Court.
Okay.
Amitabh Lordship, Lordship will kindly pay
And Lordship,
attention to the case, Lordship. The petitioner is involved in, I don't know, Lordship, 13 or 14 number of cases. The modus operandi in each of the cases are same. Vehicles are taken and then sold off. There are crime proceeds of it. Then Lordship, he obtains interim order in the name of medical ground, Lordship. He is granted interim in all the cases and directed to appear before the court on a specific date, which he do not comply with. He again comes before the Lordship and says that I am advised to go against surgery by the GMCH, no document is annexed. Again, he is directed to appear before the IO now. Now also, Lordship, he is nowhere to be seen. So all the respect, Lordship, is to run through. And in
my
the
lord, so far the
instant
cases
case,
are concerned, my lord, with regards to my learned senior submission that the no GMC order was annexed. Lordship, rightly, wrongly, the interim order was renewed. So my lord, once the interim order has been renewed, then my lord, my submission will come in the picture that since I'm adhering to the directions of this honorable court, therefore, my lord, I will be entitled to constructive custody. That will be my submission.
No, you have not appeared before the IO as per the direction of this.
That I'm not aware of since I.
No, but the case diary would reflect it had you been. Case diary is reflecting that.
My lord, if the order dated 18/12, 10/12. My lord, as and when so required by the investigating officer before the said case. So my lord, also, we don't know whether the investigating officer had also summoned him or not. In paragraph 10, my lord had directed that the petitioner shall appear before the investigating officer, Nulmati PS case number 22/25, as and when so required by the investigating officer before the said case. This part, my lord, whether they had issued any summons upon us, called us to certain things for the investigation, that has also not been submitted by my learned senior.
What is the status?
So then I will have to update the case diary, Lordship, regarding that part.
Okay, update it.
Or Lordship can produce the case diary. I can take that instruction from the IO itself because prolonging this case, Lordship, is serving no purpose.
Okay, heard Mr. S. Mitra, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. In this application under section 483 of BNSS 2023 has been filed by the petitioner, namely Dharmeshwar Roy, seeking bail in connection with Nulmati PS case number 22/2025, corresponding to GR case number 655/25 under section 316 within bracket 2/318 within bracket 4/111 within bracket 2 of BNS 2023. Stop. The petitioner has been shown arrest in connection with the aforesaid case on 5/2/2025 when
My lord, no, I was shown arrest on 1/9/2025.
uh,
The F5 is dated 5/2/2025.
on 1/9/2025 in the aforesaid case. Learned counsel for the petitioner has submitted that. Where is your first bail, interim bail order?
It's 15/10/25, my lord.
15?
15/10/25.
Learned counsel for the petitioner has submitted that in the instant case, the petitioner was granted interim bail by this court by its order dated 15/10/2025 on the medical ground, that is, he was required to undergo surgery for the ailment from which he was suffering. Stop. He further submits that in the aforesaid interim order of the bail, a direction was also made to the petitioner to surrender before the Court of Learned Chief Judicial Magistrate Kamrup Metro on 7/11/2025, and in the meanwhile to cooperate in the investigation. However, on 7/11/2025, the petitioner failed to appear before the Chief Judicial Magistrate's Court due to some post-operative infections which he was suffering from. Thereafter, on 10/12/2025, this court again extended the interim bail granted to the petitioner by its order dated 10/12/2025. No, okay, last line के लिख ले. By order dated 15/10/2025. Stop. Certain conditions were imposed while extending the interim bail order on this occasion also. The petitioner was directed to cooperate, appear before investigating officer of Nunmati PS case number 22/2025 as and when so required by the investigating officer. A liberty was also granted to the investigating officer to interrogate the petitioner inside the jail if he remains in custody in connection with some other cases. Learned counsel for the petitioner has fairly submitted that though he is not in touch with the petitioner and is unaware about the present status, however, as the petitioner has complied with this court's order, his interim bail is liable to be made absolute. Stop. The second leg of submissions, the learned counsel for the petitioner has also submitted that the petitioner was detained behind the bar in connection with the Nunmati PS case number 22/2025 for 52 days before he was granted interim bail by this court. And during the period when he was on interim bail, he has not violated any of the condition of the bail. He further submits that the period during which he was on interim bail may be regarded as the period in constructive custody of the court, so as to treat so as to regard that period as in custody for computation of period to assess as to whether he would be entitled to default bail or not. Stop. Learned counsel for the petitioner submits that the offense, what is 111 punishment?
It's organized crime, 5 years up to 111 people.
The offense involved in this case entails maximum punishment up to.
My lord, 111 was added later on. Initially, the FIR was registered under 318.
Still. Does not entail punishment up to life imprisonment or death penalty.
My lord, not less than 5 years, but which may extend to imprisonment for life.
Okay. Then the
90 days.
90 days. Oh, entails punishment which may extend to life imprisonment within bracket for an offense under section 111 of BNS bracket close. He submits that even if the statutory period of detention is treated to be 90 days, and if the period during which he was on bail is regarded as in constructive custody of the court, and said period is also computed along with the period of 52 days during which he was in actual detention, he may be regarded as completed the statutory period of detention of 90 days, and therefore he is entitled to get default bail. In support of his submission, learned counsel for the petitioner has cited ruling of the apex court in the case of Sandeep Kumar Bafna versus State of Maharashtra and another, reported in 2014-16 SCC 623, as well as a case of High Court of Odisha in the case, as well as the case of Susant Kumar Samantare and another versus State of Odisha. Within bracket CRLMC 1483/2023, wherein the High Court of Orissa deemed the period during which the petitioner of that case was on interim bail to be in constructive custody of court for grant of bail to the petitioner. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Nunma TPS case number 22/2025 and has submitted that the petitioner, in spite, has not complied with the conditions which were imposed in the first interim bail, first order by which he was granted interim bail in this case. He submits that the petitioner may not be given advantage of default bail even when he is found to be he is found to have violated the condition imposed by this court while granting interim bail. He submits that petitioner is found involved in 12 another similar cases where the modus operandi of deceiving the victims of those cases is same like that in the instant case. He also submits that what else is your submission?
Regarding now the treatment that he has stated lordship in the GMC, no document is.
He also submits that though on 10/12/2025, that is the date on which he was granted interim bail by this court. It was submitted before this court by the learned counsel for the petitioner that the petitioner had to be examined and treated in Guwahati Medical College Hospital. However, no documents relating to treatment of his treatment in Guwahati Medical College Hospital has been furnished by this, has been there in the records. He has produced the case diary. You submit the case diary. He has produced the case diary before this court. I have considered the submissions made by learned counsel for both sides and has gone through and have gone through the case diary produced by learned counsel for learned additional public prosecutor in chambers
My lord,
today itself.
my lord. Except for the conduct, my lord, I'm only on the question of law, my lord.
Yes, yes. That if I go by Odisha, the
Period will be deemed to be a constructive custody.
but that is dangerous.
My lord, that is what the honorable Odisha High Court has.
Okay, let me see.
Obliged, my lord. Time being at 44.
Which is the impugn order out of these three?
Impugn the order dated 22/6/23 and 6/7/23.
So why you have come after 2 years of passing of the impugn order?
No, my lord, I filed this application in 2023.
23 or 25?
20.
This
Earlier,
matter
there
prolonged
was an
for the
limitation.
condonation of delay.
Huh?
For condonation of delay, this matter prolonged. There was
Oh,
condonation.
okay, otherwise he came in 23 itself.
This was filed in in 23, my lord. Came up for consideration now,
Okay.
after disposal of.
So what is the status of this suit now?
24, awaiting the order of this on court, my lord.
This stay is there,
No stage there,
but it is not progressing.
not proceeding, my lord.
At
Review
this
package
stage,
of
at this stage of DW,
DW, they have filed evidence on the affidavit, my lord. Now matter is.
they only want the NJ Kids
NJ
record.
case record.
Okay,
And lordship might kind of see since last June 22, my lord, matter has been lingering for NJ case record. 3.5 years have been passed. This is an ejectment suit, my lord.
let them produce NJ cases.
Already education have already been produced some part, my lord. Only leftover part is to be there. And my lord, what result will be there if the education records are produced? Because my lord, they have already.
They want to show that they were not defaulter.
But they have already laid evidences, my lord.
No, with a prayer to file subsequent additional affidavit.
Because my lord, in this case, my lord, they have challenged 3 orders.
Which one is the last order?
Last order is 11/8/23, my lord.
Page number?
Page number 75.
What is the order?
The defendant has filed, both parties are represented. Defendant has filed evidence on affidavit of DW1, namely Nilam Chandale, along with the service copy. The learned counsel for the counsel representing the defendant filed a petition number session paid before the court for calling of the NJ case record on the basis of petition number session.
Which NJ case records?
In the case record which I have depositing the rent before the trend.
Which you have mentioned in 1373.
Yes, my lord. 173, 1373. 23. No, 675/22. And it stated before the court that the learned counsel representing the defendant could not go through the record in order to ascertain the actual order passed on 22/6.
Yes.
It stated before the court that the learned counsel representing the defendant could not go through the record in order to ascertain the actual order passed on 22/6/23 and relied upon the online order dated 22/6/23 uploaded in the e-court portal, wherein the entire order was not uploaded in the court portal. Peruse the case record, had the learned counsel was both sides. Upon perusal of the case record, it is seen that on 8/6/2022, the defendant has filed a petition for a calling of a NJ case record, but in most of the dates, the defendant has failed to call for the NJ case records on 28/6/23, last opportunity was given to the defendant to take the steps for calling of Mesa NJ case record. Even on 22/6/23, the court directed the defendant to issue reminder for the calling of the Miss NJ case, but no such record have been received yet. As such, the court has rejected the calling of the Miss NJ case record. Also, the plea that has been raised by the defendant that half order was reflected in the e-court portal could not be a valid ground for accepting the instant petition, as the order are properly reflected in the order sheets of the instant title suit. Also, it appears that the defendant has intentionally delaying the process of the court, and as such, the petition number is filed by the defendant is rejected.
What 373? In petition number 1373, what was the prayer?
My prayer was that I have categorically stated why I was not able to take the steps on the order passed on 22/6.
Okay, which are the NJ cases which you want?
In the case, I have mentioned in the petition number 675/22.
Where is that petition?
After that was there.
Page number?
Page number 48.
These 19 NJ case records.
19 index.
Only this much.
this much.
Why you took steps belatedly
My lord,
after 1 year?
no, my lord, I have in the intervening time, I have taken the steps, but some of the occasion I have failed to take the steps. And accordingly, on 18/5/2025, I was directed to pay the cost of ₹500 and take the steps. According the steps were taken, and it was sent on 24/5/2023.
Yes, Mr. Alam. It is a very small issue.
My lord. No, I
Your
have-
suit is pending.
My lord, I have been suffering, my lord. This is my suit is Egyptian, my lord.
Let him exhibit. Let him pay some cost to you.
Cost will not compensate, my lord, because.
What is your submission?
My lord, they have failed to take steps properly, my lord. This matter is pending for NG case across for last more than 3 years.
No, but
3.5 years.
after they took steps, after the office failed to comply with the,
They ought to have been brought the same to the notice of the land trial. There is no fault on my part.
yes.
Office has failed. This
Yes.
has not been brought to the notice of the court, my lord.
No, this court should also ought to have taken into consideration that once they have taken steps, it is for the office to send the record.
Then you also cannot to give a time frame, my lord.
I will take steps on the day after tomorrow. On the reopening.
Okay. Heard. Mr. R.K. Moore, learned counsel for the petitioner. Also heard Mr. N. Alam, learned counsel for the respondents. This application under Article 227 of the Constitution of India has been filed by the applicant impugning the orders dated 22/6/2023, 6/7/2023, and 11/8/2023, passed by the Court of London Civil Judge Junior Division Number 4, Kamrup Metro, in title suit number 151/2020, whereby the prayer for calling of the Miss within bracket NJ case records from the office of the Learned Civil Judge Junior Division Number 1 was rejected by the trial court, and suit was fixed for examination of defense witnesses. Learned counsel for the petitioner has submitted that the petitioner had there are many different, how many defendants?
Only one. The petitioner.
Only petitioner. Legal heirs?
Legal heirs are not impleaded. This is
This is evident position of fact, my lord, that she has been occupying the suit premises
Okay.
and doing business there.
What is your name? Neelam Oswal.
Neelam.
What is your relation to Bijay Singh Oswal?
Father-in-law, he was father-in-law.
He was my father.
That the
Neelam Chendani.
had prayed for calling of following these NJ cases from the office of the Munsif number 1, from the office of the Civil Judge number 1 in the
Junior Division.
Civil Judge Junior Division number 1 in the aforementioned title suit upward mentioned Korisune in the, in the, in the aforementioned title suit, 1 April 2023, 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 1 April to show that he has been depositing rent in court from the month of May 2020 to April 2022. Quote the NJ cases from page 49 of the NJ case. Learned counsel for the petitioner submits that by order dated, which is the first order?
18/5/23. At which post was imposed and I was delighted to.
Learned counsel for the petitioner has submitted that the trial court had initially allowed the prayer of the petitioner to call for the aforesaid NJ cases. However, why on earlier occasion you failed to take steps?
In between, I have taken steps. In some of occasion, I am able to take the remand.
However, in respect of the sum of the NJ cases, the petitioner failed to take steps. Stop. Thereafter, by order dated 18/5/2023, the trial court again granted one more chance to the present petitioner to take steps for calling of the NJ cases by depositing a cost of rupees 5,500 to the plaintiff within bracket respondents. The next date of the case was fixed on 22/6. This order is also you are impugning. 22/6. 2023. On this said date, again, the petitioner was allowed to take fresh steps for calling of the aforesaid NJ cases with imposition of cost of rupees 500.
Deposited the court.
Stop. Learned counsel for the petitioner submits that thereafter submits that the order dated which order was not reflected in the
22/6/23.
the order dated 22/6/2023 was not uploaded in full in the e-court website, and it was reflected only and next date was shown in the e-court website as for DWs/NJ records, and therefore the petitioner could not take steps on that day. However, later on which date you took steps?
On 11/8/23, I filed one application asking the trial court to allow me to take the. I have taken the steps that may be same.
Stop. Learned counsel for the petitioner further submits that on 11/8/2023, the petitioner again filed an application before the trial court, which was registered as which was numbered as petition number 1373/2023, whereby he prayed for allowing the petitioner to take fresh steps for calling of the NJ cases which were not received by the court and mention about which was made by the petitioner in his earlier petition number 675/2022. However, by the order dated
In that application, I made another prayer that after receipt of the Miss NJ case record, Your Honor may permit the defendant to exhibit the said record of Miss NJ case, because on that day I filed my DW.
Stop. Last line क्या है? No, in line. In the said application, learned counsel for the petitioner has submitted that in the aforesaid application, the petitioner also sought leave of the court to allow the defendant to exhibit the NJ cases by filing an additional affidavit, as he had already filed his evidence on affidavit, her evidence on affidavit in the said case. However, by the order dated 11/8/2023, the trial court considering the fact that even after directions of this court, of the trial court to the present petitioner to take steps for issuance of reminder for calling of the NJ case records, no records were received till that date. The prayer for calling of NJ case records was rejected, and the next date of the case was fixed for examination of defendant's witness on 14/9/2023. Stop. By the aforesaid order, the trial court also declined to consider the submissions of the petitioner that declined to consider the plea of the petitioner that as the complete order of the court was not uploaded in the e-court website, she could not take, defendant is a lady, she could not take steps properly. Stop. Learned counsel for the petitioner has submitted that the petitioner has taken steps for calling of the aforementioned NJ cases as directed by the court. However, when the office of the Civil Judge Junior Division number 1 failed to send those Miss NJ cases to the trial court as per the requisition, it was incumbent on the trial court to show cause the office of the Civil Judge number 1 as the petitioner has no role in the same. He further submits that if the petitioner is denied the opportunity of exhibiting the aforesaid Miss non-NJ cases as in the pending trial before the trial court, she would be highly prejudiced. On the other hand, learned counsel for the respondent has submitted that the trial relates to the title suit number 151/2020 is a eviction suit, and the respondent and the petitioner, who is the tenant and is in occupation of the suit premises, is intentionally protracting the trial. He submits that since 2023, because of the
It's 8/6/22.
since
8/6/22.
6/22, the trial has not proceeded.
The ground of calling for NJ case report.
The trial has not proceeded on the ground of calling for NG case. As regards impugn order, what is your submission?
This order is speaking enough that he has been causing a delay in disposal of the suit, my lord, by not taking steps time to time. So directed by the trial court.
He submits that the impugn order does not suffer from any illegality or infirmity so as to call for any interference by this court. I have considered the submissions made by learned counsel for both sides. It appears that the progress of title suit number 151/2020 has no, it appears that the title suit number 151/2020, which is a eviction suit filed by the present respondent, is not progressing any further since 8/6/2022, only because of the fact that only because of the non-production of 19 numbers of Miss NJ cases, which was called for by the court, by the trial court in pursuant to the direction, in pursuant to the, in view of the petition filed, petition number 675/2022 filed by the present petitioner.
Although my part of the NJ case records have been taken. Only leftover part is there.
Some of the NG cases,
My lord.
some of the,
None of the cases recorded.
Some of the cases records have been.
stop. Though it appears that the petitioner was also at fault in belatedly taking steps for calling of the aforesaid NJ cases. However, once such steps were taken and requisition was made by the trial court to the office of the Civil Judge Junior Division number 1, it was incumbent on the office, said office, to send those NJ cases to the trial court in connection with title suit number 151/2020. Stop. Without going deep into the merit of the respective submissions made by learned counsel for both sides, this court is of considered opinion that the under the facts and circumstances of this case, the petitioner may be given an opportunity of exhibiting the aforesaid Miss J cases, Miss NG cases, aforementioned Miss NG cases to in her defense in the aforesaid title suit. Hence, we can give direction to, hence
Take steps, if this, my lord.
not, we will issue direction here itself to the officer, to the civil judge junior division number 1.
More particularly, my lord, dealing assistant of NJ case records, man. He is separate dealing assistant in connection with NJ case record. He is the custodian of NJ case record.
Stop. As from records, it appears that the steps for calling of the aforesaid NJ cases were already taken by the petitioners. Hence, the learned civil judge, junior division number 1, is Kamrup Metro is directed to ensure that the office of the said office of the civil judge, junior division number 1, shall send the above mentioned 19 numbers of Miss NJ cases these are 19 numbers,
19 numbers of NJ cases.
19 numbers of Miss NJ cases to the court of learned civil judge
Junior division number 4 at God.
number 4, Kamrup and Guwahati, in connection with title suit number 151/2020 without fail
On or before next date fixed on 30th March 26.
on or before 30th March
26.
2026. Anything else? Nothing.
Nothing.
Okay. I was intending to impose costs.
I'm not pressing.
Okay. This civil revision petition is accordingly disposed of. No, entire civil revision petition. Connected IA is also disposed of.
State. Item 11.
Let me give you. Here my MSc case was dismissed. I approved the case by reducing evidences and
Heard Mr. A.R. Agarwala, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant Deepika Sharma, impugning the judgment and order dated 28/11/2025 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro and Guwahati in MAC case number 2002/2019, whereby the claim of the present appellant was dismissed. Issue notice to the respondent and call for the records of the aforesaid MAC case from the concerned MAC tribunal. This appeal is admitted. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 13th February 2000. Saturdays, Friday, Saturdays, okay, limited numbers. Item number? Fixed case, Nikki. Yes, Mr. Chauhan,
My lord.
your case is not maintainable. That is the submission of
Yes.
the counsel for the,
Other side.
you are impugning the
My
order
lord,
of
the-
injunction.
The second, my lord, order passed, the first order passed in the injunction. And the second, secondly, my lord, that order was reviewed and observed that it was a accidental order and typographical mistake, this is why it was altered. And my submission, it is, my lord, not a typographical mistake, my lord. And it is not accidental mistake.
No, but the, which is the impugn order?
Yes, the page. Page 108.
No, I know, I mean. Yes.
One zero eight. From page 112. One hundred from middle. Therefore, in view of the above discussion and argument forwarded by learned counsel, Mr. So-and-so, the portion of the order to do justice in this present circumstances would be to allow the petitioner to enter into the suit land, which is obviously their right and the title of the interest, which is not disputed by the opposite party, and also to enjoy the produce of the tea leaves by both the parties equally be correct below, inverted commas. To do justice in the present circumstances would be to allow the petitioner to enter into the woodland, tea garden, which is obviously their right title interest, which is not disputed by the opposite party, and also to enjoy the produce of the tea leaf, and same is corrected accordingly. Let the above accidental and typographical error be corrected. With this order, does the miss is stand disposed. Earlier order murder substantially minus 10.
What was the correction made?
Correction meant to what I read, my lord, going to read.
To do justice in the present case circumstances.
Present circumstance would be to allow the petitioner to enter into the suit land, which is obviously their right. Their means, I don't know, my lord, are they both party or one party?
Now,
Their
what
right-
correction was made?
This is the correction.
Yes.
No, which word was in?
98. It was order of injunction order passed,
Acha, wo-
but there was a typical mistake.
Which typographical
Page
mistake?
98, my lord.
that page
Page
90.
98, my lord.
Earlier, the order page from 97, my lord.
No. My question is, in exercise of powers under 152, some typographical mistake was corrected. What was that typographical? Which word was changed?
That's a page 98.
No, 98 is the order.
Last, earlier that order, that my lord. injunction
Which portion was changed?
So, my lord, page 98, the last para. To do justice in this present circumstances would be to allow the petitioners to enter into the suit land, and which is obviously their right, title, and interest,
which is not disputed by the opposite parties. And also to enjoy the produce of the tea garden leaves by both the parties.
Both the
Equally.
parties.
By both the parties, my lord, in injunction order, this typical mistake, both the parties, we have filed the application and the application, my lord, they did not oppose. My lord, kindly see the application at page 99 and page 100, lordship. And application number section 152 and 153 of the Code of Civil Procedure, 19 is amended for correction of the order dated 5/10/20 passed in Ms. Jackie so and so. And my lord, kindly see the order. They did not file any objection. At page, yes, lordship, page 109. My lord, kindly see, my lord. Page 109.
What was deleted? Both the
Both the
word.
parties, sir. Yes,
Both
that
the
order.
party allow, my lord. What is the, my lord, background of the case, my lord? The client of my learned page, my lord, plot of land. In that plot of land, by understanding by both the party, my client, my lord, invested, my lord, there a sum of handsome of money around, my lord, 15 lakh. And my lord, now tea bushes, my lord, it is grown to some extent, my lord. And and my lord, then the dispute arise, my lord. My lord, other the side, my lord, file the title suit, my lord. And they are trying to prohibit me from entering. But earlier order, both parties allowed to enter in the tea garden. By changing, my lord, only petitioner was allowed to enter in the tea garden. This is the my lord, order.
This, again, this injunction order, my lord, they did not challenge any, they did not file an appeal. Because appeal I only. Because I am the owner and they admitted that he is the owner and he was given time for 5 years to enjoy the property, and then it was more than 10 years. And my lord, then CASA agreement was made by him without the signature of the original port order, and that agreement was challenged in the title suit. Because CASA agreement cannot be entered into the, cannot be, unregistered agreement cannot be implemented. And he was trying to enter and obstructed me. That is why the injunction order was passed after hearing both the parties. And in the next, for correction, they did not object, my lord. They did not oppose. Kindly see, my lord, page,
My lord,
my lord,
we
just a
filed
minute.
no objection,
no,
my
no.
lord. Page
No objection, my lord. The
64 is the objection. Our
Kindly see, my lord, page.
64
No,
is-
not in this manner. If both of you start speaking at
That is-
Being finished, my lord. Let leave my lord.
Because main issue, my lord, that he has filed this application CRP.
no, you raised an objection on yesterday that this is an order passed under
Order 39.
Order 39 ruling.
Yes.
His plea is different.
Hmm.
He says that he is not objecting to Order 39 order because Order 39 was granted in favor of both the parties. He is challenging the order under 152 and 153 of C.
That's 152.
Therefore, he is saying that against an order under 152, 153 CRPC, revision lies. That is the submission.
My lord, my reply. My lord, when there was a mistake, under the CPC, there is a provision, to correct the judgment or an order passed by the trial court. So it was corrected after he was present, and when the petition was moved for correction, they did not oppose it. Lordship kindly see the order, my lord, its order will itself proof. Lordship, I will read the order, my lord, at page 109. They did not object it for correction. So this is an impaired order of injunction, because under order 39, both the parties cannot be allowed to enjoy, or the purpose of injunction will be defeated. My lord, 3 golden rules have been there in favor of the my lord, present respondent. Page 109, my lord, kindly see, my lord. 12/12/23. Petitioner Srimati Sushila Devgar and others are represented by Bharat Council, Mr. Soikia, Senior Counsel from Guwahati, and Mr. Yes. None appears for the opposite parties. This is an application under section 152, 153 of the Code of Civil Procedure, for correction of the order dated 5/10/23 passed in connection with the miscase number so by this court. Upon hearing learned counsel for Soikia and Mr. R.C. Soikia has for the petitioner, Mr. Soikia has brought notice to the court to the order dated 5/10/23 passed by this court in connection with miscase number 6/23 and has brought notice of this court to para 26 quoted below. The learned counsel, Mr. M. Chinardar, their counsel, for the opposite parties has taken the plea that the present suit is barred by plea of res judicata, as this court has already passed as judgment in the earlier suit number so and so. However, this plea of res judicata cannot be accepted that the earlier suit number one was dismissed merely on the technical ground, as that was suit was barred by law. Learned counsel, Mr. Soikia, has also brought notice of this court to another plea para of the said order that is 5/10/23 passed in which case number so and so, which is quoted below. Accordingly, said partnership deed has been expired on March 2018. It has been argued by learned counsel of both the parties that there is no further execution of extension of renewal of further agreement, and therefore it is crystal clear that the agreement has already been elapsed and has got no legal sanctity. Learned counsel, Mr. Soikia, assisted by Mr. Sutata, has also placed their grievance, bringing notice of this court to the last para of this order. To do justice in these present circumstances would be to allow the petitioners to enter into the suit land tea garden, which is obviously their right, title, and interest, which is not disputed by the opposite parties, and also to enjoy the produce of the tea leaves by both the parties equally. The learned counsel has also pointed out that the board has already taken note that there is a prima facie case in favor of the petitioners and dispute relating to the ownership of the shoot land, measuring 23 bighas, 0 kotha, 1 lessa, covered by the dock number so and so, and the opposite parties have admitted their ownership of the land, right, title, and interest of the petitioners, which has also been admitted by the opposite party in case number 6/23. And opposite number 1 and 3 have never claimed any right, title, and interest of the Schedule A and B land. About the present tea garden in which question is standing. Therefore, in view of the above circumstances, the arguments forwarded by learned counsel Soikia, the portion of order of the order to do justice in the present circumstances would be to allow the petitioners to enter the suit land, which is obviously their right, title, and interest, which is not disputed by the opposite party, and also to enjoy the produce of the tea leaves by both the parties, be corrected as below. So correction was made, my lord. And against this, if they are aggrieved by this correction, they could have filed a petition again before the trial court. And for this revision, my lord, now is more than nearly more than, my lord, 2 years. They are taking adjournment in the trial court. We could not advance. I am the plaintiff. Now, lordship, whether against this order, because this is an order in view of the order.
No, why suit is not proceeding?
Because they are taking adjournment in the trial court. For always be the moving petition.
No, it has not affected. It is an order passed in this case.
My lord,
But suit should proceed.
they are filing petitions. My colleague has informed me on the times that for this case, they have got a stay order and an ex parte stay order suppressing the material fact. I have filed the affidavit. My lord, kindly see my affidavit for a while. They did not annex the agreement, CASA agreement. Kindly see, my lord. Affidavit in opposition. My lord, lordship case. Lordship page 276. This agreement we have challenged because it was an unregistered agreement subsequently made by them without the original portador. Page 276, my lord. And an unregistered agreement cannot be implemented as per the, my lord, judgment and my lord, this registration act. To summarize this case, my lord. And about getting money, they are telling they enjoyed the garden more than 10 years. They did not pay me a single paisa. Above 10 years, and the period was 5 years. It was not extended. And by force, when they have made another agreement of case 278, this CASA agreement, unregistered agreement, my lord, that has been challenged in the trial court. So for
What is the
cancellation.
prayer in the suit?
My lord, yes, prayer is there, my lord. Kindly see prayer. My lord, prayer, I will place it before lordship. My lord, page 29 of his revision. Of his revision, my lord, prayer. Under the circumstances, fractions of this plaintiff pray for the relief that the decree may be passed in favor of the plaintiff, declaring right, title, and interest over the sweet land in favor of the plaintiff. For cancellation of the so-called agreement dated 13/8/19. Then page 30, my lord, for recovery of first and second position. Position is already there. Then my lord, D, for permanent injunction, restraining defendants and their main agents, workmen or any other person claiming under them from interfering in peaceful possession of the suit property, any other relief cost. So they are the payer for cancellation of the unregistered agreement, but they suppress it, my lord. And by suppressing that in their CRP, they got an expert stay order. Because they did not annex.
And the impugn order starts from which page?
My lord, in the shoot.
No, in the present case, the impugn order, which part of which you have shown.
108, my lord, case number. They are in the CRP 325/24. The order has been passed by the Honorable High Court, staying the order of the learned trial court. Order is there, my lord. Date to kiman hai? No, ekon. Seconding issue. I. Yes, my lord, and I has been filed at page 15, lordship, in IA.
Yes, Mr. Chauhan.
First of all, my lord, this garden is, my lord, lying like anything, my lord, nobody entering. What is the submission made by learned friend that we are entering the garden, enjoying the absolutely false, my lord. The parties, my lord, they are people not allowing us to enter, my lord. So that we realize the money, our invested money, this is absolutely false. And my lord, page 64, kindly see, we have not raised objection. Is alleged, my lord. Page 64 is the.
But on the date of hearing of the petition, you were not present.
It is observed, my lord, yes. It is observed. I cannot say now, my lord, perhaps it's not, my lord. That is why such observation is there. My lord, the council, my lord, conducting there, my lord, he was under the impression that the second suit is bar by res judicata because the first suit, two suits filed, my lord, by plaintiff side. First suit, my lord, dismissed on merit. And in injunction petition thereon, my lord, it was also dismissed. I have annexed, my lord, all those documents, my lord. First a plain my lord, page 114, 114. My lord, same player, same party, same subject matter.
No, no. no. The order passed by the
114.
Learned Court will be
Can you
permissible.
see my lord,
my lord.
page 114. One four is the plain my lord.
Now, who is presently enjoying the produce of tea
No,
leaf?
No,
Then how it will affect you?
Nobody.
Then how this 152 change will affect you? Earlier it was that both party will enjoy. Now you are not prevented, but he is only allowed by the 152
My lord,
change.
kindly see one, my lord, is the observation of one direction of the honorable court, my lord. Kindly see page 99. The first order, my lord, pass, my lord, like this, my lord, which is under challenge. First order, my lord, 11%, my lord, page 91. Kindly see, my lord, page 91. The first order pass in the injunction petition, my lord. Page 91, my lord, I am reading like this, my lord. In the said mail, there was a mail, my lord. In the said mail, after long discussion and deliberation, both the petitioner and the opposite party compromise their dispute amicably among themselves and enter into an agreement between the petitioner number 2 and 3 and opposite party number 2 and 3 and the defendant number 1 put her signature in the said agreement as a witness thereby. Both the parties agree mutually to extend the period of their partnership business to 15 years, which is, my lord, they themselves agreed, my lord, executed the, maybe a kacha did, my lord,
That-
but my lord.
That they have suppressed in the CCRP. What agreement we made and whether the agreement was registered or not. And whether main portal there was a signatory, they suppress it.
So, my lord, from their conduct, it is stopped, my lord, because they themselves agreed, my lord, that there was a mail, my lord, between the party and the people gathering. And both the party put their signature, executed a deed.
No, no, my query is initially the injunction order had observed that both the parties are allowed to enjoy the.
Yes.
Later on, an amendment was made and the petitioner was allowed to.
Yes.
But you were not restrained. There was no injunction on you. And now your submission is that no produce is coming out of the tea garden. Nobody is plucking any tea leaves. Then how will you be prejudiced? How it will affect your case?
So, my lord, this may be modified up to, my lord, to status quo, my lord, let the should be disposed of, my lord, on merit. Status quo may be observed. And my lord, the suit may be decided.
My lord,
We have no objection.
we have brought the government member because after all, they have challenged the order of this honorable trial court by filing the CRP. Now, Lordship, by suppressing the agreement, which was an unregistered agreement, where I am not a signatory. Because here are three porters, the main porter did not sign. And that was an unregistered agreement. By force, they entered it. By force, they have made that agreement, allegation here. Now, that agreement, they did not annex in their CRP. Lordship, kindly see the judgment.
No, no, no. We are not going into those.
Where does this CRP lie? Because this is a
If
full
my
court
lord,
decision.
that submission is
My lord,
correct, then
This is a full-
observation of
Why
that
should
is
it
wrong.
be directed for maintenance of status quo? Kindly see, my lord. Because I have invested a lot of money in the meanwhile in my land. This is my own land, they did not dispute. My lord, see kindly this order against an order of injunction. I will read the relevant portion, Lord.
No, no. His submission is that it is not an order of injunction.
Order of
It is,
injunction, because
it is an order passed under 152 and 153.
my lord implied it is an order of injunction because when the order has been passed by correcting, I am allowed, and he is not allowed because it implies.
There is no such observation that he is not allowed.
No, my humble submissions, I am allowed, I am by the last part of the order contribution, last part. Correction paragraph 15. Yes, last part. My lord. Yeah, page 112. So be corrected as follow. To do the justice in these present circumstances would be to allow the petitioners to enter into the suit land. And he is not allowed. There is no observation that he will enter.
There
Which
is-
is, my lord, which is obviously their right, title, and interest, which is not disputed by the opposite party. He did not dispute that I have no right, title, or land, and also to enjoy. When I am the owner of the land and I have right, title, and interest of the land, they should have then also to enjoy the produce of the tea leaves, and same is corrected accordingly. So accordingly, when it is corrected accordingly, that means the both the party is not there, so he cannot enter into my land.
That is not there.
My lord, this is implied, my humble submission. Now, anyway, to challenge this order, this challenge this order, therefore he should have filed this appeal under the provisions of the CPC, which the full court has held. Let me read the paragraph of full court, my lord. First type of injunction, my lord, implies, court has held up, injunction also implied, lordship kindly see.
Where?
Para 5 of the judgment that I have placed, my lord, of the full court judgment. Full court judgment. Para 5. Fall under the head temporary injunction, whereas the rule 6 to 12 fall under the interlocutory orders. It is seen thus that all orders under rule 1 to 5 of order 39 are nothing but order of temporary injunction. We lay emphasis that order 39 rule 4 is also an enabling provision to grant temporary injunction like order 39 rule 1 and 2. Among the interlocutory order, only an order passed under rule 10 of order 10 is appealable. In spite of that, of the fact that it is an interlocutory order, the expression interlocutory order means provisional, interim, or temporary, but not final. Similarly, the term temporary in expressions, temporary injunction means provisional and interim, and therefore orders of temporary injunction cannot by their very nature be final. It was not a final order. Notwithstanding the characteristics of interim, provisional, or temporary nature of orders, they have been expressly made appealable. If they are passed under rule 2A, rule 4 and 10, in our opinion, therefore, the court cannot refuse to entertain an appeal only on the ground that such orders are temporary or interim provisional. Similarly, by their very nature, interim injunctions passed under order 1 and 2 are always rendered ex parte. Even if both the parties are hurt, it is accepted ex parte. Parliament being fully aware of the situation permitted appeals against such orders. In our opinion, therefore, an ex parte order of temporary injunction, whether provisional or temporary or interim, are appealable if rendered under order 39, rule 1 and 2. On perusal of order 43, rule 1, we notice that it speaks that an appeal shall lie from an order under rule 1, rule 2, rule 2A, rule 4 and rule 10 of order 39. Therefore, any order passed under rule 1 and 2A is appealable. Lordship then kindly see para 4. Now let us turn to order 39, rule 1, 2, 2A and 4. We find out that the nature and character of the process by which an interim injunction is issued. Order 39, rule 1 states that on fulfillment of the conditions precedent, the court may by order grant temporary injunction. And what is more important, grant the order until the disposal of the suit or until further orders. Thus, an interim order of temporary injunction is clearly visualized by rule 1. Similarly, rule 2 provides that the court may by order grant such injunction. Rule 2A also provides that the court may order the property of the person guilty of such disobedience to be attached and may also order such person to be detained. Similarly, Rule 4 of Order
No,
which
Mr. Sakya.
Sure, my lord. Then last portion may can be seen, my lord. Last portion, few lines, my lord, few lines.
Yes.
It does not stand to security that if the order is an expiatory order or it is non-speaking order, it would not be revisable by the trial court order. Trial court under order such as rule 3, 2, rule 4 of the court. Rule 4 empowers the trial court to vary, alter or cancel any order. So trial court can vary it, can correct it, lordship. When we have pointed out.
No, that is not the dispute before us.
Lord,
His case is that initially when the order was passed under Order 39, Rule 1 and 2,
yes,
both the parties were allowed to enjoy the benefit of.
my lord. When they
That,
were-
no, that is,
That is
but
his submission, but.
he
what is
says
the-
that order was passed under Order 39, Rule 1 and 2.
the-
And
what-
therefore, if had he been agreed with that order, then Order 43,
Why should I go, lordship, kindly see?
but he says that his submission,
That is his
what is the
submission.
counter to his submission that,
My counter will be.
listen to my query,
My lord, my lord,
please listen to my query first.
my lord.
He says the impugn order has been passed under 152 and 153 of
53 for
CPC
correction.
for correction.
Yes.
And by exercising power under 152, 153, the trial court has exceeded its jurisdiction by making changes which were not typographical error. That is his crux of his
That's
submission.
his submission. Lordship,
You
kindly
have
see.
not countered that submission.
My lord, I'm making my submission. My lord, section 151 make kindly be seen of the CPC.
Yes. Otherwise also,
My lord, kindly see, my lord, section 151
yes.
of the CPC, my lord. My lord, saving of inherent power, nothing in this court shall be deemed to limit or otherwise affect the inherent power of the court to make such order as may be necessary for the ends of justice or to prevent abuse of the process of the court. The court has the inherent power. Then section 152 may be kindly seen, my lord. 152. Amendment of in judgment, decree or order. This was and that was an order. Clerical or arithmetical mistake in judgments, decrees or orders or errors arising therein from any accidental slip or omission may at any time be corrected by the court, either by of its own motion or on its own on the application of any party. So the court itself can correct it. Then lordship, kindly see section 153, general power to amend 153, my lord.
Yes.
The court may at any time and on such terms and as to cost or otherwise that may think fit, amend any defect or error of any proceeding of a suit in a suit, and all necessary amendments shall be made for the purpose of determining a real question or issue raised by or depending on such proceedings. 153 now, my lord. Power to amend decree or order where appeal is summarily
This
dismissed.
is not required.
My lord, so my humble prayer, when they did not oppose, when a correction was made, they did not oppose, they did not come forward, nor they file an application subsequently also. So that is binding, my lord, because they did not come up, and if there is a mistake, because it is an implied injunction, lordship, because it comes from the order of injunction, but the injunction when it was passed, there was a typical mistake. The court has corrected it. So now he is taking the plea that the court cannot correct it. The court can correct it as per the law under section 151. Your lordship has already has experience that the 151 the court can, my lord, exercise the for the justice can
Okay.
pass it, my lord.
You have to stop
My lord,
at some point of time, everybody has to stop.
my lord.
Heard Mr. S. Chauhan. I am reserving the judgment. Heard Mr. S. Chauhan, learned counsel for the petitioner. Also heard Mr. R.C. Sarkia, learned senior counsel assisted by Miss, what is it? M. Sharma, learned counsel for the respondent. Apart from making, I have hearing concluded. Before that, one line, Mr. R.C. Saikya, learned senior counsel, has also raised a question of maintainability of the instant civil revision petition. On the ground that the impugn order is an order of injunction under order 39 rule 1 and 2, and same is appealable under section order 43 rule 1 of the Code of Civil Procedure. Right, with section 104 of the CPC. In support of his submission, he has cited a decision of full bench of this court in the case of Akmal Ali and others versus State of Assam and others, reported in 1984 1 GLR 133. On the other hand, Mr. S. Chauhan has submitted that the order which has been impugned in this instant civil revision petition is not an order passed under order 39 rule 1 and 2, but an order under section 152/153 of the Code of Civil Procedure, wherein the trial court has exceeded its jurisdiction in exercising the said powers. Stop. The question of maintainability raised by learned senior counsel for the petitioner shall be addressed in the final order to be passed by this court. The judgment reserved.
Just a minute. Section 104. Any order made under the rules from which an appeal lie is expressly lying. 104. Any order passed by the court.
Okay.
Then order under 39 rule and 2 connected under order 13 rule and 2, that correction was made. So any order, Lordship, 104, section 104. Appeal line. That has been discussed by the full court in details. 104.
The 39 read with section 104 legacy.
Yes, ma'am.
Okay. Okay, wait. After BU vacation.
Let the trial, if there is the court is sitting trial court, let them release evidence, my lord, and this present revision.
I am also submitting the same thing, because my lord, in Dalgudi, my lord, very rare cases are there. Every 15 days there is.
Now you have to wait for judgment.
Yes, sir. Much.
Order 17.
Obliged.
Four 25.
Please, Lordship.
Yes.
Lordship, as per our last order dated 19/11/2025, your Lordship directed us to take steps to public paper publication upon respondent number 1.
Have you taken?
Yes, yes, your Lordship. On 4/12/2025, we've taken, we have issued notice in the newspaper, which has been annexed in which has been annexed as Annexure 1 and 2.
Okay.
Lordship, the matter may be fixed for hearing.
Mr. R. Sharma,
Yes, sir.
S. Sharma, learned counsel for the appellant, who submits that in pursuant to the direction of this court, the appellant has taken steps for issuance of notice upon respondent number 1 through publication in the newspaper, and accordingly the said notice was published in 2 daily newspapers on 4/12/2025. That is Neomia Bharta within inverted comma and Sentinel. In support of his submission, learned counsel for the petition appellant further submits that the appellant has also submitted an affidavit in compliance to that effect. The date of the notice, date of appearance, which was mentioned in the notice, is today's date, that is 9 January 2025. In view of the aforesaid submission as well as the affidavit in compliance filed by the appellant, the notices issued to respondent number 1 through substituted mode are held to be duly served upon him. Let this case be listed for hearing after 4 weeks.
Lordship, there is no service report regarding service of notice upon respondents.
When
We have taken steps in the year 2023, Lordship, long back.
you are insurance company,
No, Lordship.
so what is to be done?
Lordship, some time may be granted. We'll take instructions regarding the proper address of the respondents once again, Lordship. Here for the appellant.
Okay, heard Miss, what is your name?
M. Sakya, Lordship.
Heard Miss M. Sakya, learned counsel for the appellant. Also heard Mr. S. Sharma appearing for respondent number 3. On perusal of the office note, it appears that no updated office, that on perusal of the office note dated 9/6/2023, it appears that the notice issued to respondent number 1. What happened to 2? 1 has not returned.
The respondent number 2 service is complete, Lordship.
1 has not returned back. Stop. Learned counsel for the appellant seeks some time to get proper instruction regarding the proper address of respondent number 1, so that fresh steps may be taken for issuance of notice on the said respondent at proper address. The prayer is allowed. Let this matter be listed after 4 weeks.
As per the office note that is 6/12/2026, Lordship, postal trade consignment report of issuance of notice to the respondent is placed on record, Lordship. We have taken steps twice, Lordship.
Heard, Miss, what is your name? As Borough Learned Counsel for the appellant. It appears from postal track consignment report of the notices issued to respondent number sole. Yes.
This could not be affected. So what we want to take step through paper publication.
On
We are
respondent number.
respondent 3.
Heard, Miss, what is the name?
Sami.
P. Goswami, Learned Counsel for the appellant. Also heard Miss B.S. Ojha appearing for respondent number 1. Learned Counsel for the appellant submits that the appellant could not take steps for issuance of notice upon respondent number 3 by way of dusty mode, and praised for allowing the appellant to take steps by way of substituted mode of paper publication. Stop the paper, the prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 3 by publication of the notice in two new widely circulated newspaper in the last given address of the respondent number 3 within 15 days from the date of this order. The date of appearance to be mentioned in the notice is, give a date in episode 13th February. Let this matter be listed again on 13th February. As regards respondent number 2 is concerned, no service report has been received. Hence, the registry is directed to submit the postal track consignment report of the notices sent to respondent number 2 by speed post on the next date fixed. Let this matter be listed again on 13th of February.
4. Number 24.
None has appeared for the petitioner on call. Let this matter be listed at the date due, 7th of February. None has appeared for applicant on call. Let this matter be listed on 7th of February.
In this case, our state has filed this with RSA lordship, and there's a delay of 119 days lordship in fact.
119 days.
Yes, lordship.
Lordship, we have filed our evidence affidavit in opposition.
Objection.
Yes.
You have filed.
Yes, Lordship.
So what is your
It's
submission?
in page number 6, Lordship. Lordship, firstly, they have prepared this appeal against judgment and decree dated 28/10/2021, passed by learned District Judge Bongaigaon in title appeal number 5 of 2015. Lordship, if your Lordship peruses their IA, Lordship, in paragraph number 3, Lordship.
Para 3. Yes.
Lordship, here,
For our calculation, it is 85 days. That's
Lordship, firstly, they have not shown the calculation anywhere in the IA, Lordship. Secondly, in the paragraph 3, that being agreed by the judgment and order dated 21/8/2015, they have written. That is wrong, Lordship. That should have been 28/10/2021.
that is the
Wow. The copy that was provided to us, it is written 21/8/2015. The applicant has prepared a second appeal which bear the delay of 119 days. The cause of delay has been enumerated in the subsequent paragraphs in this application. That the appellant judgment was passed on 28/10/2021 and certified copy of the same was applied on 23/12/2021, Lordship. And it was obtained on 8/3/2022 after 3 months, Lordship. Secondly, Lordship, if your Lordship perishes our objection, Lordship. There,
No, what is the order of the judgment? Date of the judgment? 21.
21, Lordship.
This 15 is wrongly mentioned.
Yes, Lord.
Okay.
Secondly, if your Lordship peruses, Lordship, our affidavit in opposition, Lordship, there.
So they prayed for a certified copy after 3 months.
3 months. Thereafter, in paragraph number 8, Lordship, we have written that with regards to the application, it is stated that when on 6/4/2022, Lordship, the ADC Bongaigaon asked the government pleader to do the needful for filing the second appeal. And on 14/6/2022, the DC Bongaigaon had sent the case record to the senior government advocate at Guwahati, Lordship, after 2 months. they've sent it. Then thereby taking more than 2 months, the time, 2 months of time in sending the records from Boyanga to Guwahati, ignoring the seriousness of the case is not understood by the deponent lordship here. Lordship, these are not the sufficient grounds for the condonation of delay, lordship. There is no medical ground or unavoidable circumstances are not there, lordship. It is not reflected here, lordship.
Mr. Lordship, government officials, Lordship, there is not private case, Lordship. So there is some delay, Lordship, in preparing this, Lordship, it is not second appeal, Lordship. And Lordship, 21/8/15 is the
Appeal
date
was
for
filed on 26/9/2022, lordship.
Let her submit.
21/8/2015 is the Lordship, the judgment and degree of the Lordship, in the civil judge Bongaigaon, Lordship. That was wrongly written in this IA, Lordship. It is 21/8/2021. And Lordship, some delays occurred, Lordship, due to Lordship. The officials have been some.
Government is slow.
Sir, ADC, lordship, ADC took 2 months to forward it to DC, lordship. And DC took another 2 months to send it to the senior government advocate.
Subordinate, Lordship, that the employees, Lordship, not forwarded the same, Lordship, in time, Lordship.
But why it is coming up now in 2026? This IA is of 2023.
I was 2023 now, Lord,
What was the suit for?
Lordship, it was against lordship, judgment and decree dated.
What relief was granted?
Lordship, relief was granted that we have prepared an appeal. Lordship, here, firstly, the title suit was filed because we were holding the land for 40 years, Lordship. Our mother, my mother was holding the land for 40 years. There, the DC passed an order, Lordship, cancelling, where the Tozi holder and Miadi Patta was allotted to us. Thereafter, Lordship, the Miadi Patta was cancelled by the DC without just cause, Lordship. In the and thereafter, we filed a title suit, Lordship, in the civil judge Bongaigaon, before the civil judge Bongaigaon, Lordship. That was dismissed. Thereafter, we prepared a title appeal, Lordship. Here,
Oh,
the title appeal was decreed in our favor, Lordship.
that's why it was, Lordship, rejected.
on 27th
27
for orders, delivery of orders. Heard Miss D.D. Burman, learned additional senior government advocate, appearing for the applicant, as well as Mr.
W. Hawk, Lordship.
W. Hawk, appearing for the respondent. Let this interlocutory application be listed for delivery of order on 27th of January.
Obliged, Lordship.
My doctor, item number 37 and 38, madam. The case was filed on 4/3/2025. It is barred by limitation, my lord, that limitation petition could not be considered for about a year. So, my lord, after vacation, my lord, if your lordship please to fix the date, my
13 February,
37, 38.
13 February, 37, 38, 13 February.
Item number 36, my lord. Matter may be fixed on 19, my lord. The matter is fixed before lower court on 22/2, my lord. We have an interim prayer, my lord, on 19, my lord.
19,
19, sir, or reopening, my lord.
okay.
Highly obliged.
Lordship, item number 34, the next, this is a transfer application, the next date is fixed on 17/1. As per the last order, it was stated that today my interim prayer would be considered.
But what is the prayer now?
Prayer is, it could be fixed soon after reopening.
Choose the date,
As per my lord's convenience.
7th February.
17/1 is the date.
That is otherwise would also pass. 7th February.
That's right.
Item number 33, Lordship, may kindly fix the date after vacation.
4th February.
Obliged. Item number 41, the I is filed for confirmation of delay. Lordship, notice may be issued. Item 41.
Item 41 heard Miss A. Hussain Learned Counsel for the applicant issue notice to the opposite parties. Let this matter be that the petitioner, the applicant shall take steps for issuance of notice by registered post as well as by usual mode within 7 days from the date of this order, returnable on 13th of February.
Please, Lordships, I beg to mention item 31. Let the matter be listed after vacation.
It will otherwise be listed after vacation.
Obliged.
Meet Mr. Lordship.
So
Lordship
date may be
regard,
fixed, my lord. Because
The court master will give dates on other matters.
Lordship, regarding item number 30, Lordship, this matter may be fixed on 19, Lordship.
Item number?
Item number 30, Lordship. The respondent number 3 in this matter is about to file an objection, Lordship.
19 will be difficult because it is immediately on reopening day.
On any date, Lordship. Yes, sir, Lordship.
7th of February,
7.
7th February. Other dates will be given by the court master.
Highly obliged.